Thank you, and I would like to start acknowledging the traditional owners, the Yagara and the Turrbal people. And we were very grateful last week for the beautiful welcomes to country that the inquiry was able to hold, both on Monday and Wednesday. There's a few remarks I want to say at the start. This inquiry is really only in its initial stages, as we all know. We commenced on 1 July. And we've already taken a number of steps. Some of those have been very public with our hearings, and some of those we've been working hard behind the scenes, and you'll hear a little bit about that work today. We are only in the early stages, and we are very fortunate to have such a significant number of Director Generals and Commissioner of Police here this morning. But the work of inquiry and the role of government and non-government organisations will be conducted over the next 3 years. This is a preliminary step in many ways. We've made a request for submissions, and we were provided with those in August. Now's the opportunity to further distill some of those key issues the inquiry must investigate over the next 3 years. For those who did hear my remarks last week, we see the role of government as part of the second phase of the work in which the inquiry will conduct itself. Our first phase, which has already started, is on that lived experience, and we've heard from a number of witnesses, and we'll continue that process. But also too, and concurrent for that process, is steps like this. And when we get to the second phase of our work, after we largely complete the lived experience evidence, we will then turn really significantly to the role of government. That is our second phase of work, and we think that's probably at least 12 months away. But this stage and the ongoing relationship with the departments and the directors will enable us to further distill, identify, and really focus on those key issues which the inquiry will consider in our third phase of work, which is that the combination or the culmination of putting together the evidence, the documentary evidence, and making recommendations. So, and really that sets the parameters for the discussion for this session today. It is the first stage in what will be many, many, many stages of the relationship with this inquiry and government going forward. Now, just to set out some background for you and some key aspects of both the Path to Treaty Act and the role and the work here today. Early in August, the inquiry invited 13 government agencies to provide preliminary responses to a request for information relevant to our terms of reference. And no doubt most of you have read the terms of reference. And can I say we're really pleased to see such a big number in attendance today. We're always scrambling for a bigger room a few days out, so very fortunate to be able to host everybody. Now, those departments all provided submissions. In fact, it was about 1,300 pages in all, and as I say, it's an initial request, and we expect hundreds of thousands of documents to be provided to this inquiry over the next 3 years. But there were submissions dealing with issues relevant to our terms of reference, both the historical component and also a focus on contemporary issues. There was a question to tell us what's been going on basically since 2010. And we'll hear about some of those issues today. From that process, we identified 7 departments we'd like to hear further from in this process. That's not to say certainly others like education and others that we will request, we'll go through another session with them. But at this preliminary stage, the 7 departments we wanted to hear further from, and hence the representatives here this morning. I will acknowledge the really limited time frame in which we're operating and the goodwill and the effort that all departments took in responding to our submissions, our requests for submissions. Now, under the Path to Treaty Act, we can hold truth-telling hearings, which are more formal processes, and some of you would have seen those next door last week on Wednesday, Thursday and Friday, where we primarily heard from elders about their lived experience. We also have the opportunity to hold truth-telling sessions, which should be a little less formal, but certainly feels pretty formal this morning. But we do have that flexibility. And those, with the hearings and the sessions, mean we'll operate in different ways. Now, under the Path to Treaty Act, the inquiry is vested with functions that include conducting the inquiry into both the lived experience evidence and the documentary evidence, the sessions and the hearings, which I've talked about. Now, I should note too, the flexibility with both hearings and sessions means we have some components. We're a bit like a commission of inquiry or a royal commission that some of you would be familiar with. And the explanatory memorandum on the Path to Treaty Act actually speaks to those things, and I just want to read an excerpt of that Act. The inquiry has elements of a commission of inquiry, but is customised to respond to the requirements of Aboriginal and Torres Strait Islander peoples by adopting a culturally appropriate and non-legalistic approach. The model intends to encourage voluntary participation and sharing of histories, stories, experiences and truths from Aboriginal and Torres Strait Islander peoples and non-Indigenous Queenslanders alike. So it's an interesting model in that we have some powers of a Royal Commission, but we also have the requirement to be very flexible in our approach. The inquiry's ability to conduct its affairs through these different means gives effect to the inquiry's responsibility to ensure its conduct, its processes in a way which is culturally appropriate, and you would have saw both our trauma-aware and healing-informed approach last week. And I should say too, our process, and some of the witnesses I see, some of the participants here who gave evidence last week are here this morning. Our process isn't one where we just wrap support around them for the purpose of the day or the purpose of giving evidence. It's a process which is developed, relationship and support developed much in advance of that, and well after that too. The truth-telling sessions, which we're here today, our first, permits really a unique opportunity for the truth-telling and healing inquiry to deliver and engage in a way which is responsive to the needs of the community. Section 75 of the Act provides that the inquiry must not record a document or other thing given by a person during a truth-telling session if the person asks the inquiry not to record that document or thing, but I don't think that'll be an issue here today. And just noting that the submissions that we have been provided with, the over 1,200 pages, I think we're in a process of making those public online through our website over the next few weeks, as we will with the recording from this session. Now, I think I'm going to hand over to Council Assisting Ben, so if you want to take it over. But that's really, I wanted to set the framework, acknowledge the departments and the Director Generals and the Police Commissioner who have attended today on an invitation, acknowledge their thoroughness in providing submissions, but also the fact that we see this work as a very long process of building a relationship, getting access to information and really refining the issues that the inquiry wants to consider over this next phase. So thank you.
Thank you, Chair. My name is Benjamin Dighton. I appear as Counsel Assisting the inquiry on behalf of the Director of In-House Legal. This is the first truth-telling session of the inquiry in which we are to hear from the representatives of 7 government departments and agencies about specific topics related to our terms of reference. Through this session, we'll be looking to build upon the evidence and the understanding gained through the hearing held last week, in which the members heard first-hand accounts and experiences of people who either themselves or through their family members experienced the strictures of the Protection Acts, the realities of the existence of living on the reserves and missions, and lives lived subject to far-reaching government control. We'll also be seeking to build upon the theme that you, Chair, spoke to last week in your opening to the hearing, in that a society must first understand and learn from its past failures in order to improve its future. The opportunity that presents for all Queenslanders through this process of inquiry under the Path to Treaty Act is the development of an authoritative public record through detailed, balanced and open consideration of fundamental aspects of Queensland's history. It is that authoritative public record that is then able to provide an informed evidence base upon which changes can be considered that will improve our society as a whole and the lives of Queenslanders in it. In working to achieve that aim, the inquiry issued invitation for submissions to 13 government departments whose portfolio responsibilities were relevant to historical and contemporary aspects of the terms of reference. We are grateful to those departments for the written submissions that have been received and the constructive engagement in this inquiry. The information that has been provided has been important. Each department has committed, both in the words that have been contained in the submissions that we have received, but also through the actions of their presence here today, to a truth-telling process which can lead to better outcomes for Aboriginal people and Torres Strait Islander people. The need for this process is clear. As the Department of Treaty stated in its submission to this inquiry, the Department acknowledges the significant harms of frontier violence, displacement, dispossession, settlement and management of land, seas and waters, driven by the Department's predecessors' policies, legislation and activities on the languages and culture of Aboriginal peoples and Torres Strait Islander peoples. This session is a further step in gathering the evidence that details a comprehensive chronology of government policy and practice in relation to Aboriginal people and Torres Strait Islander people from the beginnings of colonisation in Queensland. That is a significant and difficult undertaking that will require considerable forensic focus. The written submissions received from the departments have recognised both the importance and complexity of that work, and in example, the Department of Justice Attorney General in their submission wrote, "The colonisation of Queensland and the authoritative stamp of a new law across the land can be marked and mapped through the establishment of the Courts of Petty Sessions and police stations. The impact of that department, under the rule of law of the Attorney General, has been far-reaching and is still being felt today. The department has a complex history. It has been instrumental in discriminatory practices that removed, isolated, deprived and sentenced First Nations Queenslanders. Yet its responsibilities also include registering births, deaths and marriages, enabling advocates for change and upholding rights." The participants from whom we heard last week in the Brisbane hearing spoke in personal detail to the effect that government policies had upon their lives and the lives of their families. They spoke to the limits placed on their freedoms, the controls over who they married, their wages, where they lived, and if or when they could see their children and their parents. The session today is an opportunity to consider those same issues told from an individual perspective last week at a broader social level in terms of government policy and the legislative architecture of colonisation. We see, for example, the stories of Auntie Leslie Williams, Dr. Jackie Huggins and Auntie Flo Watson reflected at a macro level in the submissions from the Department of Treaty detailing the policies administered over Aboriginal people and Torres Strait Islander people. And I quote here, "The relevant historical functions and responsibilities of the department under the various acts included the Industrial and Reformatory Schools Act of 1865, which allowed children to be charged as neglected and sentenced to up to 7 years at an industrial school or reformatory. Being simply identified as a child born of an Aboriginal mother was proof of neglect under the Act. The Board of General Education was responsible for the administration of the Act. However, many church-run missions and government reserves were gazetted as industrial schools. Declaring government-run reserves as industrial schools acted to expand the department's power to forcibly remove Aboriginal children to reserves, to be housed in dormitories separated from their parents for the purpose of education, thus impacting on the continuation of language and culture of Aboriginal peoples and Torres Strait Islander peoples. What followed was the Aboriginals Preservation and Protection Acts, 1939 to 1946, where the Director of Native Affairs became guardian of all Indigenous children under the age of 21, facilitating the practice of removing them from their families, the stolen generation. The government policy position at the time was that children whose mother was Aboriginal and whose father was non-Indigenous should be removed from their Aboriginal families with the objective of severing ties to the traditional Aboriginal way of life. The submission concludes that it is understood that the policy of forced removals or separations impacted on virtually every Aboriginal family in the state of Queensland, and the effects of the dislocations continue to be experienced to this day. It is estimated that 1 in 6 Aboriginal children were separated from their families and removed to institutions far from their communities. The submission goes to detail the evolution of those policies and laws into the 1960s, when the passing of the Aboriginal and Torres Strait Islanders Affairs Act 1965 operationalised the assimilation and integration policy framework. And the department acknowledges that the assimilationist policies and integration policies were based on offensive and deeply harmful assumptions and perspectives. This included, again quoting, the expectation that full-blood Aboriginal people would die out, that people of mixed descent, but not of the full blood, would eventually be absorbed into the non-Indigenous population, taking on the culture of non-Indigenous Australians. And that implicit in the assimilation policy was the idea that there was nothing of value in Aboriginal and Torres Strait Islander cultures. These are not issues that can simply be consigned as errors of the distant past that are not relevant to today. Part of today's session and the work of the inquiry going forward is to consider the long tail of these policies, the impact it has had on generations then and now. And importantly, the Department of Resources spoke in its submission to this critical process, where it said that the department noted the early administrative functions and decisions relating to Aboriginal affairs would have continued to shape the way that the department has operated since then. The department acknowledges the impact of institutional racism, prior acts of dispossession and discriminatory legislation, and is actively working to recognise and remove unconscious and structural bias and include Aboriginal and Torres Strait Islander people's perspectives in decision-making, policy and practices. The department acknowledged the displacement and resettlement of Aboriginal people and Torres Strait Islander people has had severe and prolonged impacts. In a similar vein, again, the submission of the Department of Treaty acknowledged that the acts administered by the department resulted in the largest number of removals of children. It acknowledged the deep and ongoing trauma for Aboriginal peoples and Torres Strait Islander peoples as a result of those policies, and that research shows that people who were removed and their descendants experienced a range of adverse health, cultural and socio-economic outcomes at a rate higher than those Indigenous people who had not been removed. As you have noted, Chair, this is only the first preliminary session dealing with topics of historical scale and contemporaneous complexity. It is not the purpose of today to descend into detail as yet, but it is an opportune juncture to accept into evidence the useful information that has been gathered to date and from which the inquiry will now identify further areas of work and investigation. And to supplement that process, we have invited the heads of 7 government departments today to speak further to the written submissions they have provided and answer some brief questions about identified areas of priority. Turning to the attendees for today, we have the representatives for, going in order, Ms. Claire O'Connor, the Director General of the Department of Treaty, Aboriginal and Torres Strait Islander Partnerships, Communities and the Arts, Mr. Warwick Agnew, Director General of the Department of Resources, Mr. Steve Golszewski, Commissioner of the Queensland Police Service, Ms. Yasmina Yoldich, Director General of the Department of Justice and Attorney General, Mr. Mike Kaiser, Director General of the Department of Premier and Cabinet, Mr. Michael Walsh, Director General of the Queensland Health, and Ms. Deirdre Mulcairn, Director General of the Department of Child Safety, Seniors and Disability Services. Operator, may I please have brought up on the screen the tender list for this hearing, although not necessary if you don't have it, but Chair, for the record, I tender the 14 submissions that have been received from the departments and agencies in accordance with the index that has been provided. And I note, Chair, that of the submissions were received from the departments who are not here are the Queensland Ambulance Service, the Department of Education, the Department of Employment, Small Business and Training, and the Department of Housing, Local Government, Planning, Public Works, the Department of Youth Justice, Queensland Corrective Services, and the Queensland Mental Health Commission. As you've said, Chair, well over 1,000 pages of material that has been considerable use to the inquiry. Chair, that concludes my opening, and if we now just may break for 5 minutes, we'll constitute the panel for the beginning of the session.
Before we do so, I'll adopt the exhibit list on that basis. We'll just stop to allow the media to break from filming, but our own team will continue our recording, which will be a resource we can utilise at a later date. As we did towards the end of the hearings last week, we allowed the media to film at least the first part before we went into evidence. Now, whilst we're doing that pack up, just so people are aware of what the format or the agenda will be today. Firstly, we needed to tender that evidence, so that's done. Secondly, we'll allow the heads of the government departments to make a short oral submission for about 5 minutes each. And then there'll be questions from council assisting in relation to parts of the submissions. We intend to complete today at 12:30? 12:30, so thank you.
I now invite the Director-General of the Department of Treaty, Aboriginal and Torres Strait Islander Partnerships, Community and the Arts, Ms Claire O'Connor, to introduce herself and make an opening statement.
Good morning, Chair and Council assisting. Can I acknowledge today that we meet on the land of the Yagara and Turrbal peoples and pay my respect to their elders past and present. I also acknowledge the Aboriginal and Torres Strait Islander peoples in this room and throughout Queensland for whom this inquiry is so significant. I acknowledge you, Chair, and members of your Truth Telling and Healing Inquiry who will obviously have access to the recording. And thank you for your invitation to attend this morning. My department is the lead department for reframing the relationship with the First Nations peoples of Queensland. The department has broad responsibilities across a number of portfolio areas: treaty, Aboriginal and Torres Strait Islander partnerships, communities and the arts. Within or attached to these functions are accountabilities with direct relevance to this inquiry. For example, the Community and Personal Histories branch of ATSIP, the Queensland State Archives, the State Library of Queensland, the Queensland Museum, the Queensland Art Gallery and the Queensland Performing Arts Centre. Records held by the state provide many of the facts for this statement. The department submission is also accompanied by a set of research papers commissioned from the Institute of Social Science Research at the University of Queensland. I acknowledge the work of the UQ researchers led by Professor Tim Riddell and his colleagues. There are other key researchers in the area of Indigenous affairs whose work covers this period in question this morning. And I will table a bibliography for those references for you. Chair, this morning the inquiry has asked me to focus on two particular areas: the Native Mounted Police and the creation and management of reserves and missions between 1897 and 1950. There is an intersection between these two areas which I will outline. Please be aware that some of the information may be distressing, and I have of course told people in the room. From 1859, the new colony of Queensland expanded rapidly during its first 50 years. It is estimated that at that time there were around 600 to 700 Aboriginal nations in Australia, 200 of those in Queensland. The land utilisation associated with the expansion of the colony was done without the agreement of the Aboriginal and Torres Strait Islander inhabitants, without recognition of their dependence on that land for food and water, and without recognition of their culture and traditions. Very quickly, access to Indigenous traditional lands and waters was cut off by the settlers who required that land and that ready supply of water for them, their families and their animal stock. This period of time was marked by many collisions, skirmishes, clashes between white settlers and Aboriginal peoples. In the early 1800s, Native police forces had been established by the Victorian and New South Wales colonial governments as a means to reduce these collisions and suppress Aboriginal resistance in their states. Soon after separation from New South Wales, Queensland's new governor, Sir George Bowen, wrote to England advising that he'd also established a local native mounted police, a corps of 100 black troopers stationed in detachments in remote pastoral districts for the protection of outlying settlers from the Aborigine attacks. The native police, consisting of armed and mounted Aboriginal people commanded by European officers, became the primary instrument of government control until the early 1900s. They were funded, armed and paid for by the government. They operated as a quasi-military organisation, clearing the way for non-Indigenous squatters and settlers by dispossessing Indigenous peoples of their traditional lands and dispersing them. They patrolled areas across the state seeking information on the activities of the local Aboriginal and Torres Strait Islanders who were deemed a risk to the lives or livelihoods of white settlers, their families and their infrastructure. Historian Jonathan Richards tells us there is an abundant evidence that the commanders of the native police deliberately sought to terrify and intimidate Indigenous people as much as they actively visited violence upon them. If Aboriginal people resisted being moved on, if they initiated violence against settlers or returned violence, then reprisals were extremely violent and disproportionate. What follows was a determination to punish any Aboriginals in the area. Jonathan Richards describes revenge parties operating for months. It is thought hundreds of innocent Aboriginal people were killed during this time. There is no way of knowing the exact numbers killed by the native police in Queensland, nor in frontier violence in general. Estimates range from thousands to tens of thousands. Dr. Timothy Bottoms estimates around 50,000 Aboriginals and 1,500 non-Indigenous people were killed in hundreds of incidents, while Professor Ray Evans conservatively estimates at least 24,000 were killed by the native police alone. Departmental records catalogue massacre sites across the state from mid-1800s to early 1900s, and these records are available. From 1849 to 1904, there were over 150 native police camps in Queensland. Some were short-lived, while the camp at Cowan lasted for 44 years. Over 50 years, it's estimated that some 400 officers and 800 troopers were involved in the native mounted police. In 1864, all areas of policing in Queensland underwent a restructure. The role of the Commandant of Native Police was abolished, and the new Police Commissioner David Seymour took command of the Native Police, a position he held for 30 years. They were disbanded around 1904 and had been the longest operating native police force in the Australian colony. After just a few decades of European settlement, by the 1880s, the living conditions of Aboriginal people in Queensland had deeply deteriorated. This was not only due to the activities of the native police, but to disease, starvation, addiction and displacement, and they took a devastating toll. Reports from the 1874 Aboriginal Commission on the conditions in Mackay in Queensland, followed by a Royal Commission in 1876, painted a very bleak picture of the hardships Aboriginal people endured. A change in approach was required. The government had already begun to provide land and financial assistance to various religious groups to establish church-run missions across Queensland. Methodists, Presbyterian, Anglicans, Lutherans were operating through the state on missions. For many, the motivations was tied to the belief about conversion to Christianity and the preparation of a low-cost workforce. The 1874 Commissioner, who'd been appointed to report on the condition of Aborigines, noted a number of things, including that the Aborigines are fast decreasing in numbers, diseases introduced by the Europeans are committing fearful ravages amongst the young and middle-aged, and that more than 1/4 of the entire revenue of the colony, or £350,000 annually, is derived from the sale and lease of those Crown lands which the Aboriginals occupied originally. And the Commissioners thought it was no more than just and reasonable that some small portion should be set apart and held by the government in trust for the benefit of those who are left of the tribes who formerly held these lands in possession. There was money set aside in 1875 for the establishment of Aboriginal reserves. In order to govern and operate the reserve network and to deal with the remnant populations, new legislation was required. The The introduction of the Aboriginals Protection Restriction on the Sale of Opium Act marked a protectionist era which remained in place until 1965. It was the first comprehensive Aboriginal Act in Queensland and indeed Australia, ushered in a long era of protection and segregation, during which Aboriginal and Torres Strait Islanders lost legal status as British citizens and became in effect wards of the state. With the passing of the Act, all Aboriginal reserves and missions came under the control of the government, with most being gazetted as Aboriginal reserves. Many people were forcibly removed from their country and relocated to missions far away. At this time, several key reserves were established, including Barumba, Woorabinda, Palm Island. The Act resulted in the appointment of a Commissioner of Police as the protector for all districts, and 2 additional regional protectors, Walter E. Roth as the Northern Protector and Archibald Meston as the Southern Protector. Some reserves were overseen by local protectors who were the local police officers. The 1897 Act and the subsequent amending Acts of 1901, 1927, 1928 and 1934 gave the Chief Protector of Aboriginals enormous control over the lives of Indigenous Queenslanders. They generated a large amount of records, including files relating to removals, exemptions, employment, sickness, death, marriage, government reserves and crime. Every aspect of life was scrutinised: where people lived, what they did, where they worked, who they could marry and how they could move. Their lives were recorded and governed in meticulous details by the authorities. They have been described as total institutions, places that exhibit similar features to prisons where inhabitants were separated from wider society and subjected to comprehensive controls. The legacy of the institutions, whether through the loss of cultural connection, loss of language, enforced labour or denial of basic rights, left long-lasting scars on the individuals and communities who lived through them. The 1939 Act, referred to earlier, continued to deny Aboriginal people many rights and freedoms. In summary, they were excluded from voting, unlawful to possess alcohol, restricted their movements, denied any right to lands of their birth, permitted resettlement by force, removed children without proof of neglect, forbade marriage without approval, censored, mailed, compelled work for low or no wages, and seized property without consent. Missions and reserves formerly existed for close to 100 years. Reserve superintendents, managers and local protectors kept detailed records on the lives of their charges from birth to death. There was no regard for privacy, nor did Aboriginal and Torres Strait Islanders have any say in decisions that affected their lives. Many of these records are now held by the Department and in Queensland State Archives and are available to Indigenous Queenslanders, and we acknowledge the harm and hurt caused. Chair, if I end there, I still have more details about controls, but I'll hold that, if you like. Thank you.
Thank you.
Thank you. I invite Mr Warwick Agnew, Director General of the Department of Resources.
Thank you, Councillor Assisting. Thank you, Chair. I acknowledge the Aboriginal peoples and the Torres Strait Islander peoples as traditional owners and custodians of the land, sea and community, and recognise their continuing contribution towards creating this strong and prosperous state of Queensland. I pay my respects to elders past, present and emerging, and acknowledge those of the stolen generation who are still finding their way home. My name is Warwick Agnew. I am the Director General of the Department of Resources, a role I commenced in May 2023. I would like to acknowledge the significant importance of the work of the Truth Telling and Healing Inquiry is undertaking. The work of the inquiry is a critical step, and I further acknowledge its terms of reference and its establishment under the Path to Treaty Act 2023. My department is committed to supporting the work of the inquiry as it proceeds. I know that the content of the submission from the department and evidence provided to the inquiry is at times confronting, and I encourage anyone who is listening to seek support if required. As acknowledged in the submission, the current functions of the department are inextricably linked to the early colonialisation of Queensland. Since 1886, the department has been involved in managing land and resources across Queensland, including areas of significant cultural and historical importance to Aboriginal and Torres Strait Islander communities. The colonialisation period saw an influx of European settlers into Queensland, causing widespread dispossession and displacement of Aboriginal peoples and Torres Strait Islander people from their traditional lands. Department supports the importance of understanding the full extent of the impacts of the prior laws, policies and practices prior to taking concrete steps toward healing and reconciliation. The inquiry represents an opportunity for the Department and the broader community to understand the shared history and the impact decisions over time have had on the lives of Aboriginal peoples and Torres Strait Islander peoples. As detailed in the Department's submission and administrative history, the Department's initial administrative responsibility was very broad-ranging, including being responsible for Aboriginal and Torres Strait Islander affairs and the administration of key legislation. The role and function progressively narrowed from 1905 as different functions, including Aboriginal and Torres Strait Islander affairs and agriculture, transferred to other departments. While some functions exist today for my department, such as land administration, through evolution of policies and practices, there is now a strong focus on genuine and meaningful engagement with traditional owners as part of the decision-making process. As requested by the inquiry, today I will be providing a contextual overview during the early period of Queensland's colonialisation, as it relates to the early functions of my department, particularly through the period of 1905. I acknowledge that the practices and decisions I will speak of continued past 1905. They were, however, administered by other government departments. The department's submission to the inquiry already identifies some detail, the information the department either has within its possession or can access through state archives. For example, the department can access records including detailed annual reports from the Chief Protector. These annual reports outline details such as the number of children removals, exemption certificates issued, employment and wages, approval of marriages and other matters including rations. While I will not have all of the detail in those records to hand with me today, should the inquiry seek access to those annual reports, the department will be pleased to assist facilitating where possible. So in relation to the topic of interest by the inquiries for today's session from the Department of Resources Administrative History, its responsibility for Aboriginal affairs, that in April 1903, the Governor and Council approved the transfer of the administration of the Protection Act from the Home Secretary's Department to the Department of Public Lands. The Department of Lands held the Protection Act under its administration until August 1905. It's unclear why this transfer of responsibility for the Act occurred. However, in early March 1903, the Minister for Lands passed away and J.F. Jake Foxton, who had been the Home Secretary and responsible for the Protection Act, took over the position. It is possible he took the responsibility for the Act with him. A key purpose of the Protection Act is to appoint the Chief Protector of Aboriginals. The Chief Protector was responsible for appointing local protectors within police districts. During this period, Aboriginal people, including their children, were deemed to be assisted or wards of the state. The records indicate the Chief Protector had extensive powers, including being able to control Aboriginal people's access to health and education services, employment, housing, accommodation, pensions, personal finances, and the right to marriage. Section 33 of the Protection Act provided the Chief Protector with the authority to issue certificates of exemption, which provided Aboriginal peoples with certain rights and privileges. To receive an exemption, Aboriginal peoples were required to prove they had adapted to the European way of life and had renounced their cultural identity and connections to the community. This included severing ties with families and their traditional culture and language and losing the right to return to their traditional lands. The exemptions often included conditions such as the right to control wages, employment, which could be revoked at any time. One of the most tragic aspects of the Chief Protector's role was the authority to remove Aboriginal children from their families. This function was closely linked to the Industrial Reformatory Act, which Council referred to earlier. This Act provided for the establishment of industrial and reformatory schools set up for the care and custody of neglected and convicted children and the prevention of further crime. While the Act applied to any child under 15 years of age, it specifically stated that any child born of Aboriginal or half-caste was automatically deemed neglected and therefore could be removed from their families and placed in industrial and reformatory schools. Under the Protection Act, Aboriginal peoples needed the permission of the Protector to engage in employment and were only able to work in jobs provided by the Chief Protector or other government officials. Aboriginal people living on the reserves and missions were required to participate in work programs such as domestic services, pastoral work or other manual labour. They were either paid a small wage or nothing at all, or any payment of wages were withheld by government and placed in a trust administered by the Chief Protector. The annual reports detail that children were also removed from their families by the Chief Protector and placed in apprenticeship programs, a way to civilise and train them for employment in white society, while providing businesses with a source of free or cheap labour. Under the Protection Act, rations, which consisted of food, clothing and basic medical supplies, were provided to Aboriginal peoples living on government reserves, missions and settlements. The annual report notes that rations could be withheld or reduced as a form of punishment in response to non-compliance. Coming forward to present functions of the Department of Resources, the impact of institutional racism, prior acts of dispossession and discriminatory legislation are acknowledged, and the Department is actively working to recognise and remove unconscious and structural bias to include Aboriginal peoples and Torres Strait Islander peoples' perspectives in our decision making. The Department is committed to forming genuine and meaningful relationships with Aboriginal peoples and Torres Strait Islander peoples and ensuring we walk together moving forward. I look forward to engagement with the inquiry.
Ben, before we do, I just want to re-emphasise that some of the language today will be tough to hear, but it will be taken from the legislation, and we acknowledge those were the terms that were used at the time. But if you do need support, Leanne's here, but I'm very mindful of the fact that it will be tough to hear some of those things that are expressed. Thank you, Commissioner.
Thank you, Chair. I respectfully acknowledge the Aboriginal peoples and Torres Strait Islanders peoples as the traditional owners and custodians of Queensland. I recognise the Yagara and Turrbal peoples and their country on which we meet today and recognise their connection to this land, sea and community. I also pay my respects to all present, your cultures, and to elders past and present. Can I acknowledge you, Chair, and the other members of the inquiry, and thank you for the opportunity to speak today. As the Commissioner of the Queensland Police Service, I reaffirm our strong commitment to truth-telling, reframing our relationship and healing with Queensland's Aboriginal peoples and Torres Strait Islander peoples and communities. We are dedicated to understanding the Queensland Police's past, spanning 160 years, to ensure that future actions are well considered and grounded in integrity. I do this on behalf of the women and men of the Queensland Police Service who work so hard every day to ensure that every member of the Queensland community is kept safe. And can I start by acknowledging the submission delivered by Director General O'Connor as it related to the Queensland Police, and support that submission. To prepare the Queensland Police to respond to the inquiry, we have established a dedicated truth-telling and healing inquiry team, Task Force Maiwar, within the Queensland Police Service First Nations Division. Task Force Maiwar is researching records, legislation, policies and the practices of the past 160 years to help our readiness when invited to provide records and evidence to the inquiry. Initial discussions with the Queensland State Archives have identified there are Queensland policing records relevant to the themes and categories of historical information outlined in the inquiry's terms of reference. Task Force Maiwar intends to use these records as a foundation to identify further material relevant to the truth-telling of Queensland police history. Records deemed pertinent to the inquiry will be collected, collated and catalogued into appropriate themes corresponding to each tenure of Queensland Police Commissioners, starting with David Seymour in 1864. Task Force Maiwar is sourcing records from within the service, memory institutions, historians and Aboriginal peoples and Torres Strait Islander peoples in communities throughout Queensland to research and record the true history of the Queensland Police, both historical and contemporary. Internal QPS record systems, including QPrime, being utilised to identify records relevant to the terms of reference of the inquiry that relate to contemporary matters. An internal system called IMAC will be used to assemble this information. On the 1st of August 2024, I issued a temporary document disposal freeze instructing that all records must be preserved even if they are scheduled for destruction. Some of these records will be essential to the truth-telling process. The QPS is making sure that support and wellbeing services are offered to all members when sharing information about the inquiry, including senior psychologists, social workers, police chaplains, First Nations peer support officers and external support options. The Queensland Police Service Strategic Plan and Operational Plan recognise the importance of building a capable and sustainable workforce that is both diverse and inclusive. Key activity from the Reframing the Relationship Plan is for the Queensland Police to develop and embed cultural training to enhance cultural safety and capability. Queensland Police Service cultural training capability for First Nations people is the first in-service, face-to-face training being undertaken by all members of the Queensland Police, including myself as the Commissioner of Police. This training aims to strengthen and enhance the capability of all Queensland Police members to provide culturally and appropriate service delivery and cultural safety. The QPS Reframing the Relationship Plan has been developed to support the QPS's commitment to implement the Reframing the Relationship requirements under the Public Sector Act 2022. The plan has been built around the key 8 principles set out in the Act. This plan is crucial to reframing the relationship with First Nations people and driving transformational change. The Reframing the Relationship Plan will ensure we are delivering our commitments under the Whole of Government Reconciliation Action Plan, the recommendations relating to First Nations people under the Commission of Inquiry into QPS responses to domestic and family violence, and the relevant recommendations in the Women's Safety Justice Task Force reports. The actions in the Reframing the Relationship Plan are aligned to the Queensland Police Service strategic objectives to build a healthy and engaged workforce, deliver effective and responsive policing and community safety services, ensuring our communities are safe and feel safe, and provided better services through connected and trusted relationship. The plan seeks to enable a culturally safe service that achieves the diversity target for First Nations peoples, enhances the cultural capability of staff, and continues to build and promote a positive, inclusive and diverse workplace as set out in the Queensland Police Service Strategic Workforce Plan and the QPS Equity and Diversity Plan. We are still developing our understanding of the Queensland Police Service's role in what occurred and how it still shapes us to this day. We acknowledge the recent Independent Commission of Inquiry into Queensland Police Service responses to domestic and family violence, which made findings about racist, sexist and misogynistic behaviour. And I reaffirm there is no place for such behaviour in the Queensland Police Service, and it must be addressed. The Queensland Police Service supports the inquiry and acknowledges the critical role of the inquiry in helping to redefine our organisational culture so that we can continue to build and deliver a culturally safe service. First and foremost, I acknowledge the importance of truth-telling and healing for our Aboriginal and Torres Strait Islander communities. I also acknowledge the importance of truth-telling and healing for the broader community, which of course includes the QPS. I'm here today not only to demonstrate my commitment, but my organisation's commitment to the truth-telling process, but also to acknowledge the role of the Queensland Police and the Aboriginal peoples and Torres Strait Islander peoples have going forward. To better understand the impacts and take meaningful action to change, we must listen to the stories and experiences of Aboriginal peoples and Torres Strait Islander peoples. The truth-telling process is essential for the QPS to understand our history with the Aboriginal people and Torres Strait Islander peoples and communities to move forward with positive relationships. We're fully supportive of the inquiry process and sessions to build awareness and understanding across the state about our Aboriginal peoples and Torres Strait Islander peoples' histories and cultures. Whilst we recognise there's a long journey ahead, we also recognise the importance of truth-telling and healing as being critical.
Thank you, Commissioner.
Thank you, Commissioner Golczewski. Ms Yoldic, on behalf of the Department of Justice and Attorney General.
Thank you. Good morning. Thank you for inviting me here today. My name is Yasmina Yoldic, and I'm the Director General of the Department of Justice and Attorney General. I too would like to acknowledge the traditional custodians of the land on which we meet today and pay my deepest respects to their eldest, past, present and emerging. We meet on the land of the Turrbal Niagara people. Can I acknowledge our First Nations people in the room today? I would also like to acknowledge the inquiry chairperson, members here today, my fellow Directors General, Commissioner and everyone watching today. I represent the Department of Justice and Attorney General, one of 3 Queensland Government departments in continuous existence since the formation of the colony of Queensland in 1859 and subsequently the state of Queensland in 1901. Over the course of Queensland's history, this portfolio has had many responsibilities, but principal among them has been the administration of justice. I anticipate that this area of responsibility will be of greatest interest to the members, although of course we are happy to support the inquiry's exploration of other responsibilities within the historical purview of the portfolio. Through its dozens of iterations over the years, this portfolio has also taken on a regulatory function and is also now increasingly a human services agency. I will come to these aspects during the time for questions, but with the members' indulgence, I would first like to make a short opening statement. There are parts of what I'm going to say today that are personal and sit alongside my role as Director General. It will be clear as I speak as to which hat I have on. But this is an important moment in the history of our state, and I have decided that I need to use this opportunity today to do a bit more than simply recount the department's history. Every day, I encourage my staff to bring their whole selves to work. So this is me, walking the talk. Every culture understands justice. It is a fundamental part of our makeup as humans. We teach our children right from wrong. We create systems to administer justice, ways to right wrongs, mechanisms to demonstrate there are consequences for doing what is wrong, and protections for those who are doing what is right. The way different cultures administer justice varies, and those systems change over time. The modern Western concept of equality under the law dates to ancient Greece and Pericles in 1431 BC, where he discusses how laws afford justice, regardless of class or standing. Even the concept of innocent until proven guilty is a relatively new one by historical standards. History, though, tells us the imposition of a justice system on a people, nation, or culture that has not had a role in its creation is bound to have an adverse consequence. There is an element of that in the way First Nations people have experienced the justice system in Queensland. That's not to say there should be a different system, but ensuring our justice system understands the differences of its many participants can only enhance it. I am not sure if the members know of my background, but briefly, I am of Bosnian heritage. My family fled during the war on the Balkans in 1992. The history of the conflict on the Balkans is complex and stretches back centuries, but my experience was one of religious persecution. Families we had called neighbors and friends for decades overnight turned into enemies for no other reason than a difference in faith. It's called a war, but that implies a conflict between combatants. What I saw was my people murdered. Europe and the rest of the world stood still and watched while genocide was committed. Along with 2 million others, we were forced from our homes and our lands just to survive. It took until this year, 30 years later, for what happened in Bosnia to actually be officially labelled for what it was, genocide. And even though I was still quite young, I can remember understanding the importance and significance of the International Court of Justice in The Hague, hearing the stories of Bosnian victims. And while I understand, of course, that the circumstances here and today are different, having attended the ceremonial opening last Monday, I cannot help but draw the parallels. Having the opportunity to be heard, to speak the truth, and to let that experience begin the healing. My family were blessed to find sanctuary and opportunity and a new sense of belonging in Australia. But my childhood experiences left an indelible imprint on me. I say this not to presume to understand the particular journey of our First Nations people in Queensland, but rather to give you a sense of the thinking I bring to my role as Director General every day. I understand intergenerational trauma. I understand feelings of dispossession and of division. I live it every day. For all the trauma and the heartbreak, it can't help but be a reminder of why we take up careers in the public service. We are here to serve. We are here to make the lives of others better. And while every individual's journey is different, and while every culture is built on the stories and experiences of its collective past, I can have empathy. More importantly, I can try to use the context of my experiences to think about how I would feel if placed in a situation similar to those that may be described throughout the course of this inquiry. I can use the experiences as a Director General to drive change in practice and policy in my department to address disadvantage and promote cultural safety. As a leader, It is my responsibility to create an environment where everyone thrives and delivers impactful services and policies that are mindful of this state's history and the experiences of First Nations people in that history. And if I do that, I know I will have done my part and been on the right side of history. Koala, thank you.
Thank you, Ms. Yolge. Chair, did you wish to continue with the openings from the remaining DEC Directors General? Otherwise, I can ask some questions of the panellists who've already spoken.
I'd prefer to continue if you're comfortable, Mr. Kaiser.
Sure.
Thank you.
Thank you, Chair. Thanks for your invitation to be here today. And like you, I acknowledge that we meet on the land of Aboriginal people, the Turrbal and Yagara people. And I also acknowledge the traditional owners and custodians of this country right around the state and nation. I also pay my respects to them and also to any First Nations people present today. For 165 years, the Department of Premier and Cabinet and its predecessors have been at the centre of government in Queensland. As a central agency and one of only three that date back right to the beginning in 1859 of Queensland's existence, DPC's had portfolio responsibility for many policies and practices. I acknowledge that many of those policies and practices have had grievous impacts on First Nations people, and I apologise for that. While further work is required and will be undertaken to fully understand DPC's functional history, we know that DPC has had 6 predecessor departments since the establishment of the Queensland colony in 1859. Through our research to date, we understand that the department was responsible for some policies which negatively impacted on First Nations people. Those issues are covered in our submission and have been mentioned by colleagues today. DPC is committed to continuing to confront its history to better understand the impacts of these and other policies. To assist the inquiry, we're in the process of establishing a team who will be responsible for further investigating DPC's functional history and the subsequent impacts on First Nations Queenslanders. While DPC is not today directly responsible for the administration of Aboriginal and Torres Strait Islander policy or legislation, the department does have a key role to play in ensuring thriving First Nations peoples and communities. DPC is committed to reframing the relationship with Aboriginal peoples and Torres Strait Islander peoples, recognising that the past acts of dispossession, settlement and racism have left an enduring legacy of economic and social disadvantage. DPC primarily fulfils this commitment by providing public sector leadership to achieve strong, collaborative and effective policy outcomes for Queenslanders. For example, the department is responsible for developing and maintaining the Cabinet Handbook, which sets the standards and expectations required for all Queensland public policies considered by Cabinet. The handbook includes the need for agencies to consider the effect of the policy proposals on First Nations people and to consult with the Department of Treaty and Aboriginal and Torres Strait Islander partnerships early in the policy development process. In addition, the Public Sector Commission, a Premier's portfolio responsibility, led the development of the new Public Sector Act 2022, which acknowledges that public sector organisations have a unique role and obligation to reframe the relationship with First Nations people. That Act requires public sector organisations to ensure they create a culturally capable workforce and culturally safe workplaces. This includes the requirement for departments to develop and publish reframing the relationship plans, and like other agencies, DPC has done that. DPC is also the home of the Office of First Nations Engagement and Innovation. Established in January this year, the office is led by Dr. Chris Sara. It is responsible for bringing together government and First Nations local leadership in the initial communities of Cairns, Townsville and Bundaberg, with a focus on youth engagement in each community. The initial objective is to create accords to embrace First Nations people in these regions as partners, to reframe the relationship to do things with First Nations people, not to them or even for them. Recent Closing the Gap data tells us that more needs to be done to reframe the relationship with Aboriginal and Torres Strait Islander peoples. I'm confident that in years to come, the truth-telling and healing inquiry that we're at today will be seen as a pivotal moment in Queensland's history, a transformational opportunity where the past was confronted and the foundations were laid for a more equitable, more inclusive and a more mature future. Thanks again for the opportunity to be here.
Thank you, Mr. Kaiser. Thank you, Ms. Walsh.
Thank you. I respectfully acknowledge the traditional owners of the land upon which we meet, the Yagara and Turrbal people, and their elders past and present, and also acknowledge all of the Aboriginal people and Torres Strait Islander people who are here today and who will share their stories in their lived experience and living experience throughout the inquiry. Queensland Health has made a submission to the inquiry in response to an information request, and this submission has been tendered into evidence at today's session, and I am available to answer any questions the inquiry has on the information presented. Queensland Health's submission relates to the Department of Health and the 16 hospital and health services. The Queensland Ambulance Service is part of Queensland Health, but given the separate legislation that supports its operations, it is provided as a separate section to the submission. I appear at this inquiry, as the Director General of Queensland Health. I'm also a member of the general public. In both my professional role and my personal role, I'm committed to hearing the hard truths and doing everything I can for Aboriginal people and Torres Strait Islander people to live long, healthy and fulfilling lives. Queensland Health is committed to achieving excellence in care and health equity with Aboriginal people and Torres Strait Islander people, and has several policies in place to drive reform in health services across the state. These policies include reframing the relationship plan in accordance with the Public Sector Act 2022, our First Nations First strategy, our Making Tracks Together, Queensland's Aboriginal and Torres Strait Islander Health Equity Framework, Queensland Health's Statement of Commitment to Aboriginal and Torres Strait Islander peoples, our Rheumatic Heart Disease Strategy, our Health Equity in Cancer Care for Aboriginal and Torres Strait Islander Queenslanders, and also Queensland Health's role in the National Agreement on Closing the Gap. In 2019, Queensland Health established the Office of the Chief First Nations Health Officer and appointed the first Deputy Director General level person to the role of Chief First Nations Health Office. The intent of this role is not to have this person responsible for all the work to close the gap for Aboriginal people and Torres Strait Islander people, but rather to provide the leadership and accountability to ensure that Queensland Health and all its staff focus on closing the gap. Queensland Health is responsible for leading the work on 3 of the 17 closing the gap targets. One of these targets is on track to be achieved by 2031, being the increase in the proportion of Aboriginal and Torres Strait Islander babies with a healthy birth weight to 91%. One of the targets is improving, but is not on track to be met by 2031, being closing the gap in life expectancy within a generation by 2031. The third target, significant and sustained reduction in suicide of Aboriginal and Torres Strait Islander people towards zero, is also not on track. Our First Nations First strategy provides the framework for all of our actions to achieve closing the gap and other initiatives. The strategy has 4 key areas of focus: eliminating racism, reshaping the system, transforming care, and strengthening the workforce. This strategy means we must not only reshape the health system with First Nations people, but also acknowledge the unique rights and cultural authority of First Nations peoples as the traditional and cultural custodians of our lands, waters and seas. I welcome the opportunity to answer questions about the strategy and all of our initiatives in Queensland Health.
Thank you. Ms Mulcairn, Department of Child Safety. Please.
Thank you. I acknowledge the traditional owners of the land upon which we gather today, the Jagera and Turrbal peoples, and their cultural and spiritual connection to the land, wind and waters, and I pay my respects to elders past and present. I would also like to extend my acknowledgements to the strength, determination and resilience of Queensland Aboriginal and Torres Strait Islander children, young people, carers, people with disability, older Aboriginal and Torres Strait Islander peoples, families and communities. I acknowledge the members of my department's First Nations Council, Aboriginal and Torres Strait Islander colleagues, and the Queensland First Children and Families Board for their collective cultural knowledge, wisdom and strategic advice. I'd also like to acknowledge the members of the Truth-Telling Hearing Inquiry, the Interim Truth and Treaty Body, the Treaty Advancement Committee and the Treaty Working Group, whose significant work has led us here today. It is a privilege to be here today to support the shared journey towards truth and healing. As I said, my name is Deirdre Mulkerrin and I grew up on the lands of the Jagera people. Today, the work of the inquiry is personal to me too, because as we were preparing the submission and as I was preparing for today, of course I'm here today as the Director General, but I've spent more than 40 years working in child protection, youth justice and domestic and family violence. So many of the practices, policies, decisions I have enacted, so it's personal to me. And it's a privilege to be here. The functions of the committee and the work of the department relate to the community's most vulnerable citizens, and we will all benefit from the truth-telling and healing inquiry's work to complete the picture of Queensland's history and build a more inclusive future. A principal priority across the department's functions and responsibilities is eliminating the disproportionate representation of Aboriginal and Torres Strait Islander children and families in the child protection system. It's to be acknowledged the vast majority of Aboriginal and Torres Strait Islander children are growing up in strong families connected to community, culture and country, and the impacts of our colonial history are evident. To understand where we're going, we need to understand where we've been. And the inquiry asked me to focus specifically on the time since the Carmody inquiry. So in 2013, the Child Protection Commission of Inquiry, the Carmody inquiry, was tasked with reviewing the entire child protection system and developing a roadmap for the next decade. Of the 121 recommendations made by the Carmody inquiry, the Queensland Government accepted 115 in full and a further in principle. Child Safety led or co-led 82 of those recommendations, and all recommendations from the Carmody inquiry were complete as at September 2020. What we've seen in reality, though, over those last 10 years is that despite these reforms, the demand on the child protection system has not been reduced to the extent predicted, and the system continues to grow. However, despite these pressures, the number of children that entered the system has still been significantly lower than the modelling by Carmody. And our ongoing responsibility is to continually adapt and improve the child protection system to meet the needs of families and children. In 2017, in partnership with Family Matters Queensland, we launched a 30-year strategy, Our Way, to eliminate this disproportionate representation. The Queensland First Children and Families Board, a collective of Aboriginal and Torres Strait Islander community leaders and government partners, provides strategic guidance and oversight of the implementation of Our Way. Some of the key priorities in our current round of action plans include delegating the powers and functions of the Child Safety Chief Executive to Chief Executives of an Aboriginal and Torres Strait Islander community-controlled organisation for Aboriginal and Torres Strait Islander children, ensuring that all Aboriginal and Torres Strait Islander children and young people can have services delivered by Aboriginal and Torres Strait Islander organisations within 10 years through building proportionate funding for the community control sector. I am also committed to reducing the proportion of children and young people in residential care over the coming years. While Our Way and Breaking Cycles guides our work with the sector, I am also committed to the necessary cultural change within the department. Over the last 18 months, we've been working on our roadmap to reframe our relationship with Aboriginal and Torres Strait Islander people. This has been led by our First Nations Council and involved consultation with thousands of our people across the state. And the details of this commitment has been provided to the inquiry. I'd like to take this opportunity to acknowledge the contribution of the Department's First Nations Council and thank members for sharing their knowledge, wisdom and guidance, not only in the development of our roadmap, but for all child protection policy programs and practice. This advice is crucial and as we move towards Aboriginal and Torres Strait Islander self-determination and decision-making. It is a privilege to work with them and to learn from my colleagues. Thank you.
Thank you, Mulkerrin.
Councillor.
Chair, I'll proceed with some questions to the panel at large, and we'll continue on a couple of topics, and then we'll pause for a break so that everyone can refresh themselves. First, though, may I invite Ms O'Connor, particularly at page 2 and 3 of the submission provided by the department, but it was also where you were going to before in terms of the nature of the powers and controls in the Protector era. I'd invite you, if possible, to give an overview of that to the extent that you wish to give some context to that period.
Thank you very much, Council.
And just before you do, I'll just bring up that section of the submission just so that those can follow you if necessary. Operator, it's TRE.001.0002.2. Thank you, Ms O'Connor.
So the control regime commenced with the 1897 Act. The control regime, which my colleague DG Agnew has spoken to as well, was extensive. Every aspect of people's lives who lived on the missions and reserves was impacted. If I can just run you through some of the controls.
Thank you.
Removals. So the Chief Protector, through the provisions of the 1897 Act, had the power to remove Aboriginal and Torres Strait Islander peoples and place them on a reserve and then move them from one reserve to another. The removal of Indigenous people by anyone else was also controlled by the Chief Protector. For example, Indigenous female domestic servants could not accompany employers from one district to another or out of the colony without the permission of the Chief Protector. The Act was also structured to require employers to enter into reconnaissance with their employee if the employee was to be removed for a period exceeding 12 months. There were bonds paid to the Chief Protector to cover all expenses that may be incurred, and if there was a failure to return that person or to pay his or her wages. Records for removal provide details of where people had been removed from, where they'd been taken to, and these were kept by the Chief Protector's office. Removals had to be authorised, and there were forms that relate to all of this. I have brought some of those forms with me and can table them for your benefit. So I'll just continue though. Employment and wages. The employment of Aboriginal people was tightly controlled by the Chief Protector and local protectors. Employers had to obtain permits to employ any Aboriginal person. Permits were valid for 12 months, as I said. There were agreements in place. The wages of Aboriginal and Torres Strait Islander people were also controlled. The Act provided that the Chief Protector had the power to control the wages of people living on the reserves and to apportion the net produce of their labour amongst all the Aboriginals living on the reserve. The 1901 amendment to the Act increased the control over wages and property, enabling the Protector to direct any employer of Aborigines to pay their wages to the Protector or an officer of the police. These wages would be kept in accounts administered by the Protector on the Aborigines' behalf. And the Act in 1901 also gave the Protector the right to manage all property belonging to an Aboriginal person. It followed that there were a number of trust accounts controlled by the Chief Protector and to administer those monies, and the regulations which were issued in 1904 allowed for all estates of deceased natives and unclaimed wages of deserters to be paid into an account called the Aboriginal Protection Property Account. And this account was used to control access to wages by Aboriginal people. A small percentage of the wage could be paid in the form of pocket money, with the rest being banked and accessible with the permission of the Chief Protector. In terms of marriages, there were, in the 1901 amended Act, no marriage of a female Aboriginal with any person other than an Aboriginal shall be celebrated without the permission in writing of a Protector authorised by the Minister to give such permission. The 1939 Act extended those provisions, stating that marriage between two Aborigines required the permission of the local Protector. If the Aboriginal persons lived on a reserve, the permission of the Superintendent was required. In terms of deaths, and I'm sorry that these subjects are very sensitive, that if an Aboriginal person died during a period of employment, the employer was to notify the Chief Protector within 30 days so the death could be recorded. Aboriginal people were entitled to write a will, but it was only valid if It had been approved and witnessed by the Chief Protector or a protector or officer authorised on behalf of that Chief Protector. The estates of missing or deceased Aborigines were usually administered by the Chief Protector, and where no persons could be found who were deemed entitled to the estate became the property of the Office of the Chief Protector. The exemptions that my colleagues spoke about, they were issued, but they were issued in a way where once issued, there was to be no contact between the person carrying the exemption certificate and the reserve. So that was supervised. The exemptions could be revoked at any time where, people would then become subject to the conditions on the reserves. People had to carry their exemption certificates wherever they went, and that could be demanded of them by the police to see those things. There's a lot of correspondence in our records about exemptions and in the Chief Protector's files. Exemptions detailed very personal information such as names, certificate numbers, age, marital status, savings, bank balances, residences, and whether the exemption was conditional or free. Conditions could be applied to exemption certificates. That exemption system remained in place until 1965, and it was estimated that around the time the 1939 Act came, there were approximately 18,000 Aboriginal and half-castes who were still under the state control, and around 2,400 people had been granted exemptions over previous years. So I think that probably gives you a taste of the controls. I have, and I will leave with you, examples de-identified of identification cards, social history cards, employment agreements, an application to employ, bond reconnaissance forms, marriage applications, exemption certificates with conditions, and removal orders.
Thank you, Ms O'Connor. I think there was another document you were going to table that you referred to earlier.
Yes, I have the bibliography. So
Thank
I will
you.
give you
Just
both
for the
of
sake of
those.
the record, I might get them from you now and enter them into the record. Thank you, Mr Lane. Mr Lane will grab them. Chair, I may just mark them for identification for current purposes,
Yes.
but I'm grateful for Ms O'Connor for their provision. Thank you. Chair, I'll mark them as a bibliography and an index of various certificates used in the missions and reserves after 1896. Ms O'Connor and Mr Agnew, I might come to you as well. Both of the submissions from your departments are detailed and in many places candid about events that are 50, 100, 150 years old. Stepping back conceptually from that detail, we'd be interested in your views. At a broad level, really, does history matter? As leaders of departments designing and implementing policies, what is your view as to the significance and/or the utility of understanding what has gone before in deciding how to administer the policies going forward?
I'll respond first. Yes, thank you. Thank you for that question. Can I just say that every single day in my department, history matters. We hold the keys to that history, and community and personal history section within the department has for many years been giving Aboriginal and Torres Strait Islander people back their history. It's a very active process, and I have been witness to people coming into the department over that time, and a very emotional event when people suddenly learn who their relatives are for the first time. And these people can be ordinary citizens or they can be famous athletes, and they come and they're assisted by the department. We also have the Queensland State Archives, which you've heard from colleagues around the table, is absolutely critical to this process, and they have turned to face this inquiry so that we will provide whatever support we can. Queensland Museum is also attached to the arts area in the department, as is the State Library of Queensland. They hold the history of the state together with the archives and communities and personal histories. History matters every day to us. We know what happened and we know the history of this state in terrible detail. The opportunity that presents to us, though, is to forge ahead, working in true partnership with Aboriginal and Torres Strait Islander peoples to create legislation, policy, programs that will support a different future. And that's what we're committed to. When I look at the history, you can see why we have a disparity in the outcomes, the life outcomes for Indigenous people in this state when we look at the Closing the Gap Leagues table or factors that we report on. It is obvious how we've arrived at that point, but as you've heard from colleagues around the table, every one of us takes very seriously our accountabilities now to deliver on those measures within the time frame, and that is our commitment. The other supporting priorities on those measures are about sharing data and information, sharing decision making, making sure that we support Indigenous businesses and community controlled organisations who will take that authority on themselves and they will be the ones leading that work. So I think knowing the past really gives us the best opportunity to have a different future. And I do want to say thank you to Indigenous Queenslanders and in particular elders who are prepared to work with us collaboratively as we undertake that very important work.
Thank you. Mr. Egney?
Thank you. Thank you, Claire. Can I also essentially acknowledge that it is incredibly important for us to, going forward, to recognise the truth of our past when that comes to government legislation, government policies, programs and dealings, that it is a very powerful, not only right, understanding of our past and the injustices of the past. Even looking at the Protection Act, which has been the subject of some interest this morning already, understanding that that was introduced at the time by the colonial government of the day around providing protection and welfare. It was seeking to do for First Nations peoples. It was looking to safeguard them from exploitation and the harmful effects of substances like opium as well. But on review of documents, it is plain to see on our contemporary values of the narrative and stories told that led to very perverse outcomes as well in its implementation. In particular, some of the worst effects, of course, that it suppressed considerably the First Nations languages and cultures through the practices, as we've spoken of before, around displacement, removal and re-education, children's removal from their families placed into those industrial or reformatory schools. The missions and reserves also exerted control over the Aboriginal and Torres Strait Islander peoples, which restricted their cultural practices, segregated their language groups, and was about building a labour force for the settlers of the time. Our approach in recognising our past and embedding that in our path forward is built into exercises like we have on building our future, something that the Department of Resources has been running for 7 years now. It is a very comprehensive training program, which much of the details which were proffered to you in our submission is built on, and our staff, that is a mandatory training program for our staff, and others, and I know members of the inquiry have also participated, as have ministers of government participated in that truth-telling process, that it is well structured and is very personal, and I would acknowledge the employees of my department for which that is very much their own personal story as well. We do, in understanding that, then, as I say, it's a powerful reinforcement for our ongoing commitment to recognise the colonial past of our legislation and to assure that we have an ongoing process for renewing our legislation and ensuring that institutional racism and structural bias continues to be reviewed. And I even reference recent legislative changes to the Place Names Act that went through Parliament this year. A 30-year-old piece of legislation, it was 1994 or 1995, which was and now has been changed in a way that it does seek to address structural bias in a way that our processes for consultation are now far more cultural leaning in their process and ability for the department to undertake those consultation processes, and as well as now including the obligation within that Act to look at anti-discrimination and human rights as well.
Just in your response there, Mr Agnew, there's two things you mentioned. Firstly, the removal of unconscious bias and the structural bias that exists. You referred to legislation from 1994 or 5, which is the same time in which the Native Title Act started. It might not be a question that you could answer today, but I'd be very interested in understanding whether or not your department has, in engaging in the native title process at any stage, had a level of unconscious or structural bias in the way it has dealt with native title claims, particularly because they do come from that era, which is 30 years ago. And we have seen, I guess, some inconsistencies in the approach to that process. Are you able to make any comment about that, or was that something to take on note?
I think that is something that it's an extensive topic that we would be happy to come back to the inquiry to talk through with you.
Thank you.
Thank you. Commissioner, I might come to you just on that point, in that you occupy a unique perspective in some respects, in that you are the current occupant of a position that's been in existence continuously, as you said, for over 150 years. And we noted as well, thank you for the detail about Task Force Maiwar and the work that's being done in relation to that. Your view, leading a public institution like the police, do you have views in that context of the importance of history and understanding the challenges of the present? For example, in instances where you have many officers on the front line dealing with the practical aspects of that on a day-to-day basis.
So, thank you, Council. So, quite obviously for an organisation that's been around for 160 plus years and been, in many instances, the enforcement arm of government policies of the day, some of which, as we've heard, were quite horrendous in terms of the impacts that they had on First Nations people. And I'm sure more of that will be unpacked as we go forward. Right up to today, that we are the agency that is on the ground dealing with crisis and intervention and crime in many communities across the state, but in particular First Nations communities, because that's what we're talking about today. To understand what's happened in the past and understand that that still resonates through our First Nations people and First Nations community, for both broader government, but also for my organisation and my officers, understanding that is incredibly important. Because we are an agency now that is quite different from what we saw in 1864, happily. But to understand so that we can engage and build relationships with our communities and our First Nations communities, and particularly build trust and working together in collaboration and partnerships so that we can keep those communities safer and make sure that they can thrive, we need to understand what's happened in the past and how that impacts on them. Whilst I don't expect a first responding police officer to feel responsible for what's happened in the past, that they somehow have done something wrong, they need to know that they're responsible for what happens into the future. And to do that well, we need to understand the past, and that our agency has got that continuing line right back to the start of this state, and even beyond that, even before there was a Queensland, there was a native police contingent here in the state that was undertaking certain roles of the government of the day, that obviously it's had significant impact. So look, we're very committed to that. We know there's much more to understand, and that as the research continues, we'll get a deeper understanding of what actually occurred. And I think we need to accept that some of those facts are going to be very confronting. And I expect, I will be confronted, I am confronted by the things that I've read, and continue to learn more. So we're committed to that and we'll remain so.
Thank you, Commissioner. And Ms Mulcairn, I might come to you on that point because it's a theme that you raised in your correspondence to the Chair in responding to the request for the submissions, and I'll quote, the historical context in which child protection functions and services emerged continues to have profound and ongoing impacts. This is evident in the continued disproportionate rates of child protection intervention for Aboriginal and Torres Strait Islander children and families. And you spoke as well to your personal 30 plus years of working in administering these policies or enacting them. Your views as to the relevance of history to understand responses, disadvantage, and dealing with that in policy?
Thank you. So history is important to all of us. I make sense of who I am as a person because I understand my parents and where they came from, and their childhood and their stories. So for every person, history is important to help us make sense of the world. For every community, it matters because it helps us understand where we belong and who we belong with. And I think, one of the things that, the points we made in our submission is that for many Aboriginal and Torres Strait Islander children, that sense of history and who am I and who do I belong to and where is my family, where's my mob, where's my land, what language do they speak, has been disrupted, and generations of that sense of belonging and connectedness has been disrupted. And today we see that in that the impacts of intergenerational trauma is passed forward to children. Of course, not all children, as I said in my statement, the vast majority are growing up strong and healthy families. So at a personal level, it's important for all of us, and when it's disrupted, we are confused about where we belong and how to make sense of the world. At a systems level, it is not just about the history of 100 years ago. For me, for us, it's the history of 5 years ago, 10 years ago, 20 years ago. I was an executive in the Department of Child Safety in the early 2000s when we adopted a set of decision-making tools to help our workforce make more consistent decisions across the state, no matter whether you're Gold Coast or the Cape. And I remember the work that we did. It was, we did a global search of the best possible evidence-based tools that were available for our industry at the time. And I remember many of our First Nations partners and colleagues expressing concern about whether they were fit for purpose for First Nations children and families, whether there was some sort of racial bias embedded in the tools. And it is fair to say that those messages really weren't heard and understood. And over the years, tweaks and changes happened to those tools. In the last couple of years, though, as I've taken up this job, come back to Queensland for this work, and met with particularly our board, the external board that oversees a lot of our work. Again, the very same issues were being raised with me about worries about the systemic bias that may be inside these assessment tools that we and other states have used for decades now. And so I remember I made a commitment to the board at the time that we would ask one of the universities to do an independent review of it for us and, us collectively. And I committed that when they had their results, they would come back and share them with me as the Director General and the governance board at the same time. I remember the moment really clearly. I felt like the air had stopped moving in the room when there was very clear evidence that for some of the tools, not all of them, there was some bias in them. And so the cultural wisdom and the authority of our First Nations partners at the time, we didn't hear it, we didn't understand it. And I remember the moment in that room, I remember saying, I can't unknow what I know now, and today I commit that we will work our way to stop using all of those tools, which is what we have done. Not easy, they were baked into our IT training for staff. So it is not just the people, but it's the history of the organisations and the organisations that we all represent. I hold today significant powers in the lives of children and families in this state, and I carry that responsibility with me. And with that comes a responsibility to understand both the past, but also our recent history and how that impacts.
Thank you.
Ms Mulcairn, a couple of questions on that point. So if I can just walk through what you've said. So roughly 20 years ago, Indigenous workers informed the department that the tools that you were using at the time had a level of structural discrimination or bias, is that correct?
That's correct.
Now, those tools were used up until which date?
I think we stepped away from those specific tools about 18 months ago, 2 years ago now. Maybe a little longer.
And
It's in the last couple of years.
your commitment to cease using those?
Mm-hmm.
Are there any, has the department undertaken any inquiries or investigations to understand if the structural bias that existed in those tools impacted upon the way it dealt with specific cases of children?
So, thank you for the question. As the Chair would be aware, some of those tools were used at different points in the child protection system. So it might be about how we screened in information that we received from the public. One particular tool was about understanding the strengths of families. So there are many, many layers of decisions, of people making decisions. No one tool on its own influences the decision or is the decision. People make the decision, and then particularly serious decisions like the removal of children from their families are not decisions that we make. We present the evidence to a magistrate, and the magistrate considers the evidence. So it is hard to say this particular tool that may have triaged information in a certain way it definitely wasn't the decision in relation to specific children. I think the other thing that is fair to say is that probably one of the most profound impacts of taking that decision is that my First Nations colleagues, and this is what they have said to me, felt really for one of the first times that their cultural wisdom about how children are raised and the experience of Aboriginal and Torres Strait Islander children was truly respected as our partners. So I think it's actually had a more profound impact on the work that we have been able to do since with our First Nations partners. It was probably one of the first big steps in saying that we genuinely wanted to reframe the way in which we worked with First Nations children and families and our partners.
So there hasn't been a specific inquiry or investigation into, for example, the Family Matters in New South Wales looked at specific cases?
No, that hasn't happened here in Queensland, because the tools that I was referring to relate primarily to the intake decision-making tools. So every year the department receives 140,000 inquiries or reports. So that would be 140,000 inquiries about all children in the state, not just Aboriginal and Torres Strait Islander children, of course, over decades and decades.
You won't have these to hand, and I don't expect you to answer this question now, but if I look back then around 20 years, and just roughly with the dates, I'm looking at data which you don't have. Indigenous children in out-of-home care in 2002 in Queensland was 708, according to AIHW. 10 years after that, we go to 3,041. And then 10 years later, we're at 4,508. is it possible the tools had an impact on the numbers of children, Indigenous children in care?
I genuinely don't believe that that's the case. I think it is a much more complex question than one or two tools. It is, I mean, it is the, it's, I think it's helpful to look at the rates per 100,000. I mean, I would be the first as the Director General to say that there is, you know, over-representation in our system. But Queensland's over-representation is at the lower end nationally. We are the state that other states look to for the work that we're doing in relation to over-representation. So the proportions per, of course, the population is vastly different than it was 20, 30 years ago. And as I said, the tools are one part of many layers of decision-making about any child in this state.
And the last set of questions I had, we heard evidence last week about families who had been removed, stolen generation over 2 or 3 generations
Yes.
impacted. What weight does that, do those generational removals have in the consideration which your department deals with children who are coming in contact with the system? And I'll maybe reframe that, but is there any consideration for the fact that in some families they might have been removed for 4, 5 or 6 generations?
Yeah, yes. So for all families, there are some families in the state for whom the child protection system, Aboriginal, Torres Strait Islander, non-Aboriginal, their contact with us is generations, you know, generations back. So in the work that we do, we look at both the issues and risks for children and their safety, and importantly, the strengths and what we call protective factors for parents and families. It is absolutely true that today we understand in much more detail and depth the protections that family, extended family, connection with kin, connection with community plays in the role of supporting families in a way that we definitely didn't understand 40 years ago when I first started as a brand new child protection worker. It is also the reason that, as outlaid in our submission, that we are doing so much work about transitioning the statutory work that the government agency that I lead does to the community-controlled sector. I mean, I hold a very strong view that I am very proud of the work that my agency does every day. I'm very proud of the people who work in it. And we are a white mainstream statutory organisation, and we can never provide the kind of cultural support and cultural safety that a community-controlled, First Nations-led organisation can, and that our partners in the sector who know community and have a strong sense of connection to families. My workers can't be that as an agency, which is why we are determined to transition as much of the work that we can for First Nations children and families to First Nations organisations.
Thank you.
Just before we leave this topic, we're going to come to it later, but I'll just add one question now, which is whether or not the department is able or has been tracking the effectiveness of the implementation of the Aboriginal Child Placement Principle as part of that suite of measures to look at over-representation of those children.
Yeah, thank you for the question. So it is embedded into our legislation, it's embedded into our policy and practice, and definitely on the best advice of our First Nations colleagues internally and our partners in the sector, that the Aboriginal Child Placement Principle is what's guiding our decisions for Aboriginal and Torres Strait Islander children. So we know that there is strong evidence that children, as I said before, who have a sense of belonging, a connectedness, understand who their clan is, where they belong in their country, have a stronger sense of, belonging, and that impacts on every aspect of their lives. I think the thing that is most relevant in relation to sort of oversight or evaluation is the work that Commissioner Lewis from the Commission of Children and Young People has undertaken in the last couple of years. It's called Principal Focus. So when Commissioner Lewis proposed that she would exercise her powers as a commissioner to undertake a many-year evaluation and oversight of our implementation of the Aboriginal Child Placement Principle, we've welcomed that, and she's already issued one report. I think for us all now, it is not the question about whether it's the right policy, without a doubt. The question for me, for us, is always about the implementation of it, the delivery of it. How can I be assured, how can we collectively be assured that whether or not you are living and growing up in Currumbin or up in the Torres Strait, that our work reflects that. So for big service delivery agencies like mine, the easier question is, what is the right policy? The hard question is always, and can you deliver it consistently, ethically, with integrity in every place across the state?
And only because this is important for work that we've got coming up, so I'll ask one more question before we leave it. Is that evaluation, consideration of effectiveness and implementation at all a feature of the Our Way strategy or any of the underlying action plans?
Yes.
It is?
Yes.
And
yep.
Can you just very briefly describe?
So I think I called out in my opening statement some of the work that we've committed to with Family Matters Queensland, QATSIP, our Child Protection Peak, the Oversight Board, is the particularly delegated authority, is the work that we're doing to transition the powers that I hold under the Child Protection Act to the CEOs of community-controlled organisations. So QATSIP, our partner, the Child Protection Aboriginal Peak, has work underway about research that is Aboriginal and Torres Strait Islander led, so designed and led. It would seem inappropriate that the white mainstream organisation evaluated the usefulness of what is, basically a very strong cultural practice. So our partners in the peak are undertaking work.
Thank you.
I should note I've got a personal conflict with one of the employees at QATSIP in terms of a close family relationship.
Okay. Thank you, Chair. Thank you, Ms Mulcairn. We may pause there to give you a break, and then Ms Yoldige, Mr Kaiser, Mr Walsh, will come back to you after that.
Thank you.
Thank you, Mr Dighton.
Thank you, Chair. Ms Yoldige, the submission from the Department of Justice and Attorney General deals with this notion of shared history as well, and in some nuance in terms of the complexity of the good and the bad that arises when you consider any type of departmental, governmental agency. You referred to in the submission is the fact that the department is engaging with the Griffith University to develop and produce a research paper, and the reference says that it examines what historical factors have shaped justice and regulatory institutions, policy and practices that have impacted First Nations people in Queensland since 1859. I'll ask you just to speak to the impetus for doing that work, but if you could also invite you to answer as well whether that will then deal with how that feeds into the current barriers and impacts that has in doing the work of the department going forward.
Great, thank you. Thank you for the question. As briefly mentioned in my opening statement, the department currently known as the Department of Justice and Attorney General has had many iterations and names over the course of its 150 plus year history. For the sake of simplicity, today I will use the current name or the acronym DJAG rather than the various name iterations. DJAG administers a wide array of legislation over the course of its history. Currently, we have more than 210 acts on our statute books, about 3 times the number of the portfolio that administers higher than the number of the portfolio that comes in second after us. As I noted in my opening statement, DJAG is most noted for our role in the administration of justice, being the department at the axis of three arms of the Westminster system, the executive, the parliament and the judiciary, further complicates our history, especially in the early years before the Federation, when the Attorney-General took on functions now more associated with the public service than the executive arm of government. DJAG is also somewhat unique in that some of those 210 plus acts we administer are enforced by other departments. The obvious example being the Criminal Code, for which DJAG has policy responsibility and the Queensland Police Service has operational responsibility. That's one of the reasons it's important to think of DJAG as part of the broader justice system, including the current iterations of the Queensland Police Service, the Department of Youth Justice and the Queensland Corrective Services. Jointly, these four departments, along with the independent judiciary, make up the Queensland's modern justice system. DJAG's role in relation to discriminatory practices involving First Nations Queenslanders therefore centres on our responsibilities within the administration of justice. Police have investigated and arrested, courts have sat in judgment, and prisons have incarcerated based on laws administered by DJAG. The legislation that was developed and implemented has had profound implications for Queensland's First Nations peoples that echo to this day. The complexities across the history and the different configurations and responsibilities of DJAG require further detailed consideration and research to fully understand that. It is for that reason, as you mentioned, that we have engaged Griffith University to conduct in-depth research into how justice institutions and processes have impacted Aboriginal and Torres Strait Islander peoples in Queensland since 1859. I will elaborate on this research in my response to the other question the inquiry has foreshadowed, but it is imperative that we work through this early history with other departments such as the Queensland Police Service and the Department of the Premier and Cabinet to explore our shared histories, as this is where DJAG shares historic responsibilities such as the Native Police and the administration of the Aboriginals' protection and restrictions of the Sale of Opium Act 1897, which have had lasting impact on First Nations people. As mentioned, we have commissioned Griffith University paper to scope major historical themes in justice institutions and processes that have impacted our First Nations people from 1859. The research is proposed to be conducted across 3 phases, with final report expected in May 2026. Phase 1, which is underway now and will continue in 2025, will include engaging with Queensland State Archives to understand the history of the Office of the Attorney-General and the department. It will also rely on the expertise of Griffith University researchers in accessing external resources, with consideration that the sources of history, who has written those records and accounts, as well as how the information has been captured, will be based on the society and the systems of the day. Therefore, the university will also access primary documents from various sources and consider Indigenous law and customs passed down via oral traditions. In Phase 2, historical case studies will be developed to help inform the truth-telling and healing inquiry. Phase 3, in the final phase, Griffith will formulate an historically informed and culturally aware justice improvement standard for First Nations Queenslanders who come into contact with the justice system. The timeline for delivery of the research will include an initial report in late 2024, with Phase 1 completed around March 25, Phase 2 around September 25, and Phase 3 in May 26. The research will be conducted by preeminent researchers with extensive background on Indigenous history in Australia, including Professor of History Mark Fernane, who consulted on the Royal Commission on Aboriginal Deaths in Custody in 1990 and has many publications on the history of criminal justice, policing, punishment and criminal law in both Australia and Ireland. Of course, history matters. It shapes us who we are and it shapes what we do in the future. What I will emphasise, though, as I said in my statement, who writes history is also really important to take into account. It can't be a white person's recollection of history and documentation, and that's why the Griffith University piece of work that we have commissioned is really important, that we look at all of the artefacts that exist, but most importantly, that we engage with our First Nations people to really understand the stories and the history and the storytelling of that history. I do want to emphasize again that who writes history really matters, and that's why it's important to do this piece of work. I know it will take a while, it will take a couple of years, but getting it right matters. As I said, it shapes us who we are. Most importantly, it makes sure that we don't repeat the same mistakes that we have made in the past. And of course, it will inform my department's future work.
Thank you. And the offer has been made in the submission, but I imagine here now that it would be possible for that work to be shared with the inquiry as it continues.
Most certainly, absolutely.
Mr. Kaiser, I might come to you, but I'll lead off on a theme that I'll also extend to you, Mr. Walsh, and also you, Ms. O'Connor, in due course, which is really accepting everything that's been spoken to in detail and candour here. We come to a point where we consider, as we must in our terms of reference, where are the barriers, where are the impacts, what are their effects going forward, what can be done to mitigate them. And we won't go into that detail here, but it is important to understand where we are at. Both of you have, both you and Mr. Walsh have referred to closing the gap in your submissions and your presentations. Both of you have spoken to the need to reframe, and that flows from the statement of commitment from the Queensland Government about that relationship and the need for it. Can I get you then to speak at a high level about the concept of reframing, because propositionally, ask you to comment, it incorporates the notion that something is not working, something's not right, and there needs to be a shift to bring about a series of improvements or measures that can change the trajectory of where we're headed. Can you just speak through that reframing in a practical sense as DPC driving government towards that shift?
Sure. I think it's obvious from what's already been heard by the inquiry that, you know, Queensland's history of racism and dispossession of First Nations people has led to, you know, really disproportionately poor outcomes, generational outcomes in terms of economic and social advantage. And, you know, a lot of that has come about because white governments sought to do things to Aboriginal and First Nations people. There have been other times in our history and other policies which could be characterised as government seeking to do things for Aboriginal people in a sort of a superior kind of benevolent sense. But neither of those approaches, obviously not doing things to Aboriginal people, but even not doing things for Aboriginal and Torres Strait peoples really reflect that sense of partnership or mutual respect or recognition or self-determination. And so neither of those approaches in our history have been particularly successful, which is why you see, you know, results in the closing the gap statistics, which are still so far from where they need to be. And they certainly don't, even beyond closing the gap, they certainly don't speak to or provide opportunities or envisage really Aboriginal and Torres Strait Islander people's excellence beyond just closing gaps. And so when we talk about reframing the relationship, we're really talking about getting to a point, like was stated in the statement of commitment, getting to a point of self-determination and working with Aboriginal people and Torres Strait Islander peoples. So, you know, the statement of commitment talks about self-determination, respect, locally led decision-making, empowerment, shared commitment. It talks about all those concepts which make it feel much more like a partnership where there's mutual respect, but also an ability to hold people accountable as well. Government in terms of holding local leadership of Aboriginal and Torres Strait Islander people accountable, but also their ability to hold us accountable for outcomes. So when we talk about reframing the relationship, that's certainly my sense of that. And that's manifesting within government in a number of ways. We've heard, you know, as a result of the Public Sector Act 2022, agencies are required to have reframing the relationship plans. Our own plan is a mix really of some very practical things, like trying to procure more First Nations businesses to do work with us, trying to lift the proportion of First Nations people within the department as employees, but also more cultural and mindset matters as well beyond those statistics. that go to really cultural awareness and trying to build an understanding amongst public servants of what our history is and also what a partnership looks like, as opposed to, kind of benevolence coming from a sense of superiority or doing to people. So it's not about doing to or even doing for, it's about doing with.
Thank you, and thank you for going to the statement of commitment. Part of what follows on from what you spoke about in the statement of commitment is, and I think it's a line that you also mentioned in your statement, is the fact that of an enduring legacy of economic and social disadvantage. In leading the DPC with a pan-government view of the work that is being done, are you able to identify any areas in the department's view you think are of key urgency or priority where that gap is either not closing at all, not closing fast enough, or where the real barriers to which this inquiry should be directing its attention should be top of the list? And again, I won't press you. If you want to think about it, come back to us.
No, and I thank you. We might come back with a more fulsome answer, but one thing that does immediately spring to mind is the idea of early intervention with young people. DPC presided over the creation of a policy called Putting Queensland Kids First, which is an attempt to get state policy oriented far more to early intervention in young people's lives. This isn't particularly a First Nations issue, it's a more general issue, but we certainly hope to have an open dialogue with First Nations people and co-design with service providers with those cultural capabilities, some services which intervene far more early in a young person's life to create better social and economic outcomes for them and the people around them.
Just a question, Mr. Kaiser. You mentioned accountability, and if I could sum up what I've heard this morning, it's generally from representatives of government that we've failed you for 160 years in various forms. I think that's probably an appropriate summary, yes. And really this might be the first opportunity then to create a level of accountability. What does a level of accountability look like as a model for Aboriginal and Torres Strait Island people and their relationship with government going forward? Is there any thought around that?
Well, in general terms, I think accountability is about an opportunity to hold people to what they say they will do and the outcomes that they'll seek to achieve. That's what accountability means, I think. I'm going to, with your indulgence, I'll talk a little bit about the work of Dr. Chris Sara, who's working now in the Department of Premier and Cabinet. He's the CEO of a group that we call First Nations Engagement and Innovation. It's a new team within DPC established by this Premier in just January last year. His work is an attempt to reframe the relationship at a very local level in 3 specific communities across the state. And he gave me the benefit of his views about it again yesterday. He talks about the need to build an enduring relationship with local Aboriginal and Torres Strait Islander leadership that gives them the ability to hold government to account for the outcomes and commitments it gives, but also gives government the opportunity to say to its partners in the outcomes that we're seeking, you undertook to do certain things, where is your performance on that? And until we're able to get to that kind of relationship of mutual respect and the ability to hold each other to account for the things that we say we'll do and the outcomes we're seeking to achieve, then we won't have reframed the relationship.
Thank you. And the second question I had, it was your reference to young people, which is obvious of interest to the inquiry. And I guess it's the relationship between child protection, the DJAG and QPS, for example, with watch houses. And I'm wondering on how do you bring those different departments together that have key interests, youth justice and others, in really setting up a strong framework so you are looking at holistically what happens to young people. So if you've got a young person who's on a child protection order, they're sitting in a watch house because they can't get bail and they haven't gone to school for 2 years. What's the approach in dealing with those types of issues?
It's very challenging because the Westminster system establishes silos within government and puts people at the top of those silos that are accountable for what happens in their silos, not necessarily accountable for what happens around cross-cutting outcomes that government might want to seek to achieve. So that's been a problem with the design of the Westminster system for 400 or 500 years, that it's really quite challenging to get cross-agency collaboration when people at the head of agencies are actually held accountable for just what happens in their agency. So certainly central agencies like DPC and also Treasury do seek to bring agencies together to, to try to help create the circumstances for collaboration that achieve outcomes to which each agency needs to contribute. And an initiative we've taken recently through a unit within DPC called the Implementation Unit is seeking to do just that. It's not the only mechanism, but I call it out as a real attempt to get agencies to focus on their contribution to a broader outcome rather than just the outcomes that they seek from a single program, for example, within their department. But it's challenging, Chair.
If I'm
Ms Mulcairn, sure.
If I might contribute, given that you made the specific reference to children child protection. So, as my colleague has referenced, over these last couple of years, we've been working hard with our colleagues in youth justice and police and justice to understand who are the children and young people who are in touch with all of those systems. So I can tell you today the number of children who are on child protection orders, also on youth justice orders, and where they are, what kind of placement they're at, what sort of history they have. So I know today it's 219, for example, children on child protection orders, also on youth justice orders, so that's all children. But I think the work that we've been doing together is to make sure that the relevant agencies at the local level are all at the table together to share the information that we have about the children, young people and their families, what support services are already in place, who is best placed to reach out to families. So to share the responsibility and accountability in relation to trying to not think about those children and young people as my colleague said, in a silo, but to see them as a child, as a young person with a family in their community, often needing support, often needing other services. And it's only by us all sort of sharing that and putting it on the table and then just adding whatever it is that we can, that in fact we are seeing much better outcomes for those children and young people. And we are all being held accountable, not just for the work that we're doing individually, but for our contribution to the collaboration together.
Thank you. I've just been asked to remind everybody to refrain from recording. We're recording the sessions, but there's strict controls around our recording, so please don't record, and we'll publish this session in due course. Thank you, Council.
Thank you, Chair. Mr Kaiser, I'll come back to you with a big question, but an important one with which the inquiry will be concerned going forward, so work your way through it to the extent you can. But you spoke in your answer about accountability. You spoke in the submission, or your department's submission about DPC's role to drive government's work from conception through to implementation and evaluation. And what the inquiry is particularly concerned with is a history of things being done, but the risk of either problems and successes not being measured or not being understood so that the issues keep recurring. Can I get a sense from you or a comment as to what, in your view, are the key metrics of success or what success might look like in this reframed relationship of a systems approach to building better outcomes for Aboriginal and Torres Strait Islander people?
Well, I guess, in its most obvious form, it's around those closing the gap metrics. It's certainly, there's a metrics part to it. There are things that can be very easily measured, and we monitor those, and we've got a view about what's on track and what's not, and what's working and what isn't. But beyond that, it's about mindset and culture as well. And I'm of the view that we can't really necessarily get to closing the gap and to addressing those issues of historical and persistent social and economic disadvantage unless we start really start with mindset and culture. And that's why, I think some of the cultural awareness work that we're doing within government, within my agency and within many other agencies, is really critical. I remember my own experience of going through one of those cultural awareness sessions held by an external First Nations consultant, and it was very confronting, and it fundamentally changed my view about the way I go about now assisting other agencies and my own agency around policy making. It was very pertinent, very confronting, and has had a long-lasting impact. So, that's an attempt at cultural and mindset change, which I think has to go hand in hand with the more kind of fundamental measurable things like we see in changing the gap, closing the gap.
And we're speaking more philosophically here, so I'm happy, I'm not asking you to delve into the detail, but culture and mindset can be notoriously difficult to measure at an institutional level.
Sure.
Are there, and I'm asking, you're all leaders of departments, so please contribute. There may not be raw metrics or percentages that you can attribute, but are there indicators that you look for in your departments that suggest shifts in mindset and culture in the right direction, or ways in which a lens through which these things can be viewed?
There are. I think, I'm not sure they're terribly sophisticated, but we have, for example, the Working for Queensland survey, which asks staff on an annual basis about their view of the department, their attitudes to certain issues, what they've observed about their colleagues and their experience of the public sector. So there are things that we do that seek to monitor culture within the organisation. I'm sure they can be improved upon, but we make that attempt.
Thank you.
Mr. Kaiser, your experience with the cultural awareness training, it's really a journey that all Queenslanders have to go through in some form, through this truth-telling process. But the truth-telling inquiry's powers are limited in terms of we can make recommendations, and we'll only, our terms is for 3 years. There is probably a greater role, though, from government, isn't there, to take all of Queenslanders through that journey, that process that you've been through in some form. What I'm saying is the inquiry can only do so much.
Sure.
It only has so many resources, so much reach, and a limited period of time. But if you can participate in a cultural awareness training over the course of a few hours or a few days and have a really significant change from it, isn't that a journey all Queenslanders need to participate in some form?
I'm not quite sure how we operationalise that, but I think it would be terrific if they did. I know, as I said, it had a profound effect on me, and I learnt a lot, and I think it's fundamentally changed the way I approach my work within government. I'm not quite sure how we operationalise the idea of every Queenslander going through that experience. In many ways, I see this inquiry as, and the publicity that comes from it, and the work that comes from it, and the report that comes from it, and people's participation in the room today, as all contributing really to that kind of mindset change and cultural change within our state, not just the public sector.
Thank you. Sorry, Councillor.
No, thank you, Chair. And just before I move on, did anyone else have any other comment? Anyone want to add? Thank you, Ms O'Connor.
I can probably add to that what DG Kaiser has said. The opportunity to open the archives where people deem that suitable, because it does contain personal histories, but to have the rules around what can be accessed and to make that far more available to the Queensland community as a whole is there. I think the other work we do with...
Just that's an important point. I just want to make sure I understand it. Are you saying there's a barrier in place at the moment that needs to be removed, or that something can be changed?
No. What I'm saying is at the moment, the Queensland State Archives holds a range of records that Queensland may not realise are there.
I understand.
And also some of those records pertain to very personal things, so there have to be a set of decision rules around who can access what. But I do believe they could be made far more available. For the past 2 years, Minister Enoch has been very determined to work closely with the archives to make sure that Queensland was a signatory to the declaration that would decolonise the archives and make them more available. So that process has been underway. So there's that. There's also records held by government departments that could be made accessible depending on the level of details that people would be prepared to release. And I think the other opportunity is, of course, through educating and the educational institutions, whether they are from early childhood through to university, to make sure that there is that inbuilt access to Queensland's history. So, you know, for me, there are some obvious first steps that we can take to make the history available. The other thing I'd say is, in terms of measures, Queensland and Australia aren't on their own. The OECD, for example, it measures across a number of life domains about how different countries are progressing. In relation to closing the gap, the National Committee has determined a number of priority reforms that are the foundational layer, and they're things like Mike has talked about in relation to shared decision making, making institutions accountable, as in government institutions, a strong and sustainable community controlled sector, and Indigenous Queenslanders having access to locally relevant data and information. So some of that harks back, of course, to the examinations of productivity commissions, where they've looked at investment versus outcomes. And in some cases, we were putting money in, but the outcomes were poor. We weren't working in the right way and with the right people. So I think that there is opportunity for service delivery reform to come from those priority closing the gap reforms, which will inform where we are. But the practical thing is, there's a level of disadvantage that has been embedded over a long period of time, and it's hard for people to get on top of that. And when you look at things that we deliver, whether it's education, health, housing, we've got a lot of work to do, and colleagues at the table have expressed how they intend to do that and be accountable for it.
I will say, Mr. Kaiser and Ms. O'Connor, that and thank you both for your responses. It is very front and mind for the inquiry as to how we bring all of Queensland along with this journey. So your input is invaluable in that. And yes, the inquiry should make recommendations about the education system. That is in our terms of reference. So, you know, that will be one way. But other ways, we are thinking about how we can create that public awareness along at the earliest stages, not just through the media. And one of the tools we'd like to use is something adopted in Queensland, New South Wales, which is the towardstruth.org website. I think we've got one of the researchers who worked on that, fortunately now working in the inquiry, but getting access to those types of records so that we can start that early program or approach in terms of public awareness. But I thank you both. Just want to say in respect to those responses, and it is a significant priority for us in starting that journey early. Thank you.
Thank you. Mr. Walsh, thank you for your patience. We pick up directly where we left off with both of these witnesses, in respect that health perhaps sees in the plainest detail in terms of the data some of the manifestations of disadvantage over a long period, and you spoke frankly to that in the closing the gap section of your opening statement. From a health perspective, can you give us a sense in your view or in the department's view as to where the barriers lie and, where possible, the nexus with the main causative factors or the drivers that you see behind the disparity of outcomes for Aboriginal and Torres Strait Islander people?
Yes, it's a very large challenge to reshape something like the health system, which is the largest single organisation in Queensland, to ensure that it provides services that are both experienced by Aboriginal and Torres Strait Islander people well, and also that the outcomes that they receive are well, and that is two very important elements. Can I just go back to about accountability, because I think accountability in my mind is an action word, and words are words, documents are documents, but actions tell the truth of the matter. And my, the hardest thing about ensuring that the services are able to deliver what people expect when they come along, that people feel comfortable and capable, they don't feel like the services are racist, they feel welcomed, they feel like the person is interested in them, is about ensuring that we're able to recognise the past, to actually learn from those mistakes. But my view is that the history is so important because it actually tells us how urgent the change is, and how important and urgent it is. And that's certainly the messaging we put throughout our organisation. And I want to use three sort of frames to talk it through. One is we actually have to change, or like legislation has to exist and to support doing things better into the future and ensuring that all Queenslanders have access to the same outcomes in health. And that comes from central agency reframing the relationship right through to health legislation that has Aboriginal and Torres Strait Islander people on boards of all of our statutory bodies, has the requirement for all services to engage with their local Aboriginal and Torres Strait Islander communities, wherever they are in Queensland, to actually develop a joint health equity strategy with those communities. And so that legislative framework is important. That has to be underpinned by strategies and policies and practices that we need to ensure have no racist bias to them. And we know from the past, from work that independent researchers have done, that a lot of policies in our agency do have those biases, and as we find them, we try and eliminate those. And that's really the first part of the second frame. So if I talk about legislation, strategy, policy, practices, and then it's the actions of staff in that one. But then our strategy talks about, and we make actions, and we're progressing the way through this, eliminating racism. But it's about making sure that everyone undertakes cultural capability training, that everyone, that actually racism is talked about. If you don't talk about something, you don't notice it, and if you don't notice it, you can't change it. And so that's a really important part of what we do. We then have to turn that awareness into actually reshaping how we organise our system. It's absolutely critical in the health space that we have a really strong, vibrant, community-controlled health sector that actually is able to provide health services to their communities, but also have the ability to influence the way that hospital and other health services provided by the department or a hospital and health service are provided as well. So unless there's strength in that, we won't have a complete and strong system. And that way, in order to do that, we actually have to invest in that space. And like this most recent budget, it has been the largest single uplift in the community-controlled Aboriginal and Torres Strait Islander health sector in the history of Queensland Health, which is a really important part of putting some action to our strategies, not just actually. And one of the real key elements, in fact, we had a forum in this very room a few weeks ago with all of the sector, and the important part of what this funding to the sector is that we actually had the commitment from the government that the funding was about improving health services to the sector, but it didn't stipulate how. So the forum was to actually come to the sector and say, for the first time, we're saying there's this much money on the table, and we're working with you to work out how that's best delivered for your communities. And that was a really powerful conversation to have. It was, and the whole idea we were doing there was, this is about a true partnership. A true partnership isn't that one side brings what they perceive as the answer. It's that both sides turn up to create the answer. And so that was a really I think it's really important to see that as going in. So it's really trying to eliminate the racism, reshaping and creating partnerships, then investing in that. And then the last one, which I colloquially will term the most important thing, and that is actually our Aboriginal workforce and our Torres Strait Islander workforce. Because if our services don't reflect the communities that they provide services to, then we're failing those communities and we're failing the people in those communities and the employment. We're often the largest employer in a lot of these communities, and we would want the workforce to be reflective of the community in which the service is operating. Now, we fall short of that in nearly every location in Queensland, but we're not shying away from the fact that that's our goal, and that we're happy to be measured and accountable and to put on the table the actions we're doing to try and achieve that. Such as the most recent Aboriginal and Torres Strait Islander workforce enterprise bargaining agreement. In Queensland Health did a couple of things that are significant for Queensland. One is that people who work in that workforce are all either Aboriginal or Torres Strait Islander people, and they will have access to 10 days cultural leave on top of all the other entitlements that they have, such as sick leave, annual leave, long service leave. So that's enshrined in our enterprise bargaining agreement. And the second is that we created a mechanism to recognise cultural authority and experience the same as a professional qualification is recognised in terms of promotion and remuneration on a scale. So I think what I would say is it is important that organisations like Health are accountable. That accountability is about action, and that at the end of the day, whether we're successful in providing services that meet the needs and are welcomed by Aboriginal and Torres Strait Islander people it's what they say. It's what they say about the services when they turn up. When I go and talk with them, if they're telling me that they're not happy with them, then we haven't achieved our outcome.
Thank you for that detail, and just stepping that through in a similar way I did with Mr. Kaiser. You explained very clearly that process and those frames. Can you comment at all on, if that plan works, what success looks like in terms of how you measure it? Are there key metrics? We've got the broad raw numbers of closing the gap, for example, but there's a wealth of indicators that would lie under that may show a more granular version of what's working and what isn't. Mm-hmm. For the inquiry looking forward, are there key things that you look at that think, if that is a tick, it would show a trajectory that we want to keep going in? Other key areas that you look at?
So I think in the two ways that Health measures is both in outcomes, which are essentially, if we take the closing the gap targets, then and the three for Health are life expectancy, healthy birth weight, and rates of suicide. And there are a whole lot of other outcomes in terms of rates of chronic diseases, heart disease, cancer, and so forth. And I think those are well embedded, or they're well known. I actually think where we have to do the work is on the whole other side, which is the experience outcomes or targets. And we do in Health, they're called patient-reported outcome measures and patient-reported experience measures, PREMs and PROMs. We just like acronyms. And the outcomes are mature, in terms of from a health service point of view. So from a health service point of view, longevity of life or healthy birth weights is seen as a good clinical thing. But there's the other element of outcome is the person's quality of life improved? And so that's the hardest thing, or one of the hard things we're doing now is trying to get how do we actually ask a person whether they think the outcomes of the health their health service was beneficial to them. They may have a longer life, but they may not be feel like they've got a well life, or and what is it that we've missed out on? And that is for both, or that's for Indigenous and non-Indigenous people, and it's different. Every culture and every person is different. But then it's also the experience. Like you can get a healthy outcome and have a racist experience, and that's not what we want. We want the experience to be welcoming, engaging, culturally supportive and safe, and we want the outcome to be good. And so what we're doing is developing those measures. Now, we're doing that as many other services across the globe are doing it, and it's hard. It is very hard to get those measures and to get them in a way that is reflective. The thing in saying all of that, what I'd say is actually I personally, and all of the deputies and all of the leaders, it's actually you've got to go out and talk to people. Because if you're not constantly engaging with the communities that you're providing services for and hearing what they want to say and need to say, you're not going to be able to get those measures. And in the absence of having those scientific ones, that's the best place that I find. I was just wanting to do the one last frame was about the truth-telling and healing inquiry. And in my mind, the process that we're trying to engage in our organisation is about, well, we actually do need truth-telling, but we actually need honest hearing as well, and we need healing action. And so it's absolutely critical that everyone, and including myself, takes that approach. It's like, I need to hear the truth, I want to hear the truth, I will hear it honestly, and I will take healing action in response to that. And that's what I'm judged on, is the healing action that I take.
Thank you.
Mr. Kaiser, just back to you. Excellence. I've just been thinking about your response. And when I look out the close the gap, there's some points where I would think we're setting the bar low. The bar is finishing grade 12 and working for a period of 6 months. That's the measure. And it might be, we don't care how you finish as long as you finish grade 12. There is no, in those close the gaps, and this is where I think the setting the bar is, there's no expectation people will go on to university, for example, which would be a key driver in terms of success in employment and career opportunities in the future. And when I look at that current measure, it really reminds me of what I heard last week in our evidence. We were trained to the lowest level. We were educated to the age of 12, grade 4, grade 6, there was some evidence last week. And then we were set out to work with our hands as domestics or on stations. And so looking at that, there looks like a further generation, when I look at those measures on Close the Gap, that we're really potentially locking ourselves into those the lowest common denominator approach of the past. How do we then take this discussion, how do we take the discussion to excellence, well, and not even excellence, but to university? How can the measure actually be university when everyone's focused on potentially the lowest common denominator?
Yeah, I mean, it's a very good question. Why aspire to average?
Yes.
You know, closing the gap is a comparison of averages in every metric for non-Indigenous people compared to an average, or a mean for Indigenous people. And so a lot of the closing the gap framework, I think, is about dragging one average up to meet the other average, and it's all not very inspirational.
Yeah.
It's necessary. I mean, those differences in averages are very real issues being felt by people who experience that social and economic disadvantage that we've all talked about. So I'm not saying it's not a worthy aspiration, but it's not particularly inspirational, I guess. And there are other measures you can look at beyond closing the gap, like university, education, attainment, and other things. But just in terms of the various frameworks, I think the point I was trying to make before is that reframing the relationship. is a frame of thinking. It is a mentality that does allow you to take account of or aspire to exceptionalism as well. It's not just about aligning two sets of averages, which closing the gap very much is. And so, in my mind, reframing the relationship as a framework which is much more encompassing than closing the gap. Closing the gap is, in a sense, minimalist. Reframing the relationship is getting to a point where, as I said before, we're no longer doing things to First Nations people. We're not even doing things for First Nations people. We're doing them with them. Where there's that sense of co-design, that mutual responsibility, mutual accountability, and it's a genuine partnership.
Thank you.
Thank you, Chair. Chair, this inquiry, as we've both said, is in its early stages, yet we've had the benefit now of 7 heads of their departments giving their time and engaging constructively and meaningfully in hard questions. We've had the benefit of detailed submissions which have informed a lot of our work. So we are grateful for that. And as to conclude now, I open it up. If there are any further remarks that anyone wish to make that they haven't had the opportunity to do so, please take that time now.
I wouldn't make, I'm mindful of Mr. Kaiser's comment previously about the traditional constraints of a Westminster system and government working in silos, and I just want to flag that I think that's a very important point. But also note that there's been some positives, and I think there needs to be discipline held and commitment held to those positives, which are the agencies coming together to work in a systems-based approach to improvement, but to also flag that there's some risk in that. That if you push a problem up to a systems-wide approach to it, you can tend to take the nuances out of it that need to be in that. So any design or transformational approach across systems at a government level where you have multiple agencies working together, and we all, a number of us here sit on the Community Safety Cabinet Subcommittee, Directors General thing, and we recently did some work around custody, looking at that, and the Chair mentioned that before, around watch houses, looking at the end-to-end custody, what does that look like? That if you go to the really macro system, you can sort of take away some of the issues that are of concern here for this inquiry and make it one size fits all. So there's some risk there. But it's an important piece of work that needs to be done. And I wanted to give the example that, you know, from a policing perspective, we're frequently in a system where other things are at play that prevent improvement. And there's tensions, for instance, at the moment with rising crime in Queensland and what we need to do about that. So our approach in policing, of course, is to ensure community safety. And that means more arrests, more investigations, more interventions, and we're knowing that what we're doing then, of course, is that we're increasing incarceration of First Nations people. And in particular, if I want to talk about youth justice, First Nations young people who are significantly overrepresented. And then that leads us into a system where we're putting them into watch houses, which, you know, the 64 odd watch houses in Queensland, I'd like to say that they're all state of the art. And they probably were in their day 60 or 70 years ago when they were built. So we as an agency have committed to a very detailed piece of work around reviewing our watch houses and trying to improve that, and ultimately that'll end in a discussion with myself and government around what we can do there. But we won't fix, because that's not a systems approach. Because people will still be forced into watch houses, and they'll be staying in watch houses, and young people will be staying in watch houses if we don't do the work across the whole system. So I just wanted to flag that from our perspective. We see the opportunity going forward as where government's doing now is working together collaboratively across the agencies and looking at the problem from a consistent approach in a partnership way going forward. And I think that needs to be maintained.
And just to understand the practicalities of this, because you're right, there are competing tensions whichever way you go, silo, high level across. But for instance, are you saying a bail question may relate to are they in out-of-home care question, which may relate to what are their youth justice support worker question? Is that the...
So, in really simple terms, so I call it a production line of youth offenders.
Yes.
It starts at the age of criminal responsibility. They remain in that system until they become 18 and exit that. We get engaged with them when they are committing offences of serious concern, and the options for us to deal with them have been taken away from us. So we're dealing with a criminal justice response where an offence has occurred and working within a system that allows certain things to happen. What's happened to those children before they've turned 12 is beyond the remit of the Queensland Police Service largely. So we're not dealing with that. So the only way that we can address that is working collaboratively with the other agencies around those kids that are most at risk to enter into that production line of criminal offending when they reach that criminal responsibility age. So, and there's some really promising work happening in that space, but it's going to be challenging because there's here and now pressures around community safety that we have to address as well. So we continue to put children in watch houses, which is not what we want to do.
I understand. Thank you for that contribution.
Ms. Yoldich, I'm just looking at your independent justice portfolio bodies, and we've got 4 minutes left, so you might be the last question. And one of those is the Office of Queensland Ombudsman, and we're talking about watch houses. You don't have to answer this now, but there is recently published a report on watch houses in Cairns and Mergen, I believe, and some examples put into those. Is there what steps does your department take in response to those types of reports, or is it something that you collaborate with QPS on?
Thank you for the question. So as you may be aware, the Ombudsman reports to Parliament, doesn't report through the Director General. So we do take the reports, obviously, go through them systematically and look at the recommendations that are made through those reports, and also collaborate across other affected agencies in terms of how we take on those recommendations.
Thanks.
Thank you.
You want to sum up? Sorry, Mr. Kaiser?
Sorry.
Yep. Sorry, I fear I may have caused some offence amongst my colleagues in terms of my comments about collaboration and silos. So I thought I'd just quickly take the opportunity to correct that misconception. I didn't mean to offend, and for the sake of my internal popularity within government, I just want to make it clear that I acknowledge really hard work that goes on by people, here and elsewhere to collaborate and to try to work together in a systems approach to achieve outcomes. I acknowledge that work, but I just want to reiterate the point that I think we are a long way from taking a genuine person-based approach to aligning services in relation to a person's needs, or even a place-based approach in terms of aligning what we do to a region's needs.
Thank you.
Thank you.
Well, that might draw us to a close. We've had scheduled for a 12:30 finish. I want to thank the Commissioner and the Director Generals who have attended today. Again, the response in the submissions and the frankness in which they've answered their questions this morning has been greatly appreciated. I also want to emphasise too, for all of those in the room, that our terms of reference of the inquiry, we must focus on the current barriers and obstacles to Aboriginal and Torres Strait Islander people's full participation in the public, economic and social life and public affairs of Queensland. And unpacking that terms of reference means we must delve more deeply into what are the issues. What are the structural issues that are facing? We've heard this morning and in the submissions some of the really good things that are happening, but certainly it will be our strong focus to understand where things aren't working. What are those barriers? Because it's those barriers under our terms of reference which we must investigate, inquire into and make recommendations about. I thank everybody for their attendance, and particularly Director Generals and the Commissioner today. Thank you, and that closes this session.